Hey, chat. Good evening. Sorry for the minute. I was having trouble getting the thumbnail to load. It's kicking my ass. But welcome to the show tonight. I know we're talking about the Corey Richards trial. Apparently, something weird happened today in that where the judge made them stop filming, things like that. We're going to catch up on day 4 and 5 of that tomorrow. I think that makes a little more sense. A little easier. We'll just kind of we'll take that whole thing at once. But we are going to get into their ads. That's not my I'm not in charge of the ads department, trust me. If I was in charge of the ads department, I'd be getting paid a lot more money than what I do doing this. So ah so anyways, guys, welcome. Welcome to the show. And what did I just knock onto my foot? I don't know what that was. Oh well, whatever it was. Anyways, welcome to the show, guys. My name is Sean, also known as Potentially Criminal. I'm an attorney in the Cleveland, Ohio area. Tonight we're going to talk about Alyssa Mercante, a Smash JT's lawsuit. And then we're also going to cover a couple of other cases that are still kind of pending out there that have not been resolved as far as things are concerned. Two other lawsuits, the Stuttering John lawsuit and the where he's suing the who are these podcast guys, and also just an update as far as Ethan Klein's stuff is going against obviously not Casey Tron anymore, but Denims and Frogan. They're just going to be mentioned real quick. There's not a whole lot of updates. There. But I just wanted you guys to know we could talk about those. So that's kind of the goal tonight. And then obviously we'll get into the main thing here. What's going on with Smash JT's lawsuit? Did they ruin an easy win? And I've talked about this before, guys. Following the rules to make sure the rules are complied with 100% can make or break you. And then also discovery can make or break you. And, just following discovery, discovery can cause a lot of problems. And this is a situation where I'm not going to take Alyssa and her attorneys at their face value here on what's going on. But, based on what the court's having to deal with, there's some issues. There's some issues. It looks like they're getting resolved, but this stuff could go very badly very quickly. So that's just kind of where we are on things. So we're going to get into all of that here. So I guess the first one we'll talk about real quick is the Ethan Klein lawsuit versus Denims. Once again, I don't understand naming yourself after a pair of jeans and a pair of fabric, but hey, she's a makes sense given who she is. She's a retard. Remember, Ethan Klein is suing Denims and Frogan. Remember, those two are some of Hassan's hoes for copyright infringement regarding the content Nuki made about the bravest of all the Turkish warriors out there, Hassan Piker. And then remember, he had also sued Casey Tron, but Casey Tron had settled out. Casey Tron had to give her, yes, actually, Amon Rezu, yes, as Darkside Phil will talk about, it comes in denims when the tasty bananas come out. Razor Fist is celebrating the failure. Why? I mean, that, if just yeah, well, we'll get to this. We'll get to this and why this is a fucking retarded thing here. But yeah, we'll get to that. We'll get to that. We'll save that one for later. Remember, Ethan Klein sued them. They also sued Casey Tron. Casey Tron settled out. Casey Tron had to give an apology, and the apology was, remember we went through that. It got televised, and she had to suffer through it. And everybody's crying, oh, it's so mean. It's like, that's a lawsuit. You have to grovel and kiss ass. And Ethan Klein made her grovel and kiss ass. So that left us with two other cases. That left the case against Frogan, which has kind of stopped. The case against Frogan is just kind of like frozen in midair. And then the case against Denims is in stasis right now. And that's because they're trying to get information from Reddit and trying to get subpoenas done about the Reddit mods and the H3 Snark mods so Ethan Klein can rain unholy Jewish fire upon them. And, you love to see it. You love to see it. So that is kind of where we are with that. And for the Ethan Klein, and Denim's lawsuit, real quick, it's on hold. It's on hold right now. It's all on hold, and the ultimate issue now is going after. We'll get to who JT is, okay? We'll get to who JT is. You guys can we'll calm down on that one. We'll get to that. We'll get to that. We'll get to all that. Anyway, what happened with Ethan Klein and Denims? Remember, it's TED Entertainment. That's Ethan Klein's company. That is Lex Luthor Industries. Yes, a front corporation for Shin Bet and Mossad versus Alexandra Marwa Saber. Or Marwa Twat. I don't know how you pronounce that. Abdel Mana whatever, Denims. Denims. Anyways, they are suing. What are they asking for? This is a motion to stay proceedings pending results of the resolution to quash the Reddit subpoenas. Remember, the Reddit mods they had some subpoenas. They've responded to all of that. The case has not been sorted out all the way yet. So as of right now, they want to stay. And they're both agreeing to it. And they point out the court granted some expedited discovery. There were subpoenas served on Discord and Reddit for the Snark mods and all the people involved running gay ops on Ethan Klein. And then the parties already had their discovery conference back in August. The Snark mods did not participate. They had no input on all of this. They've done a lot of work in the meantime. They pointed out that the Snark mods intended to file their motion to quash back in September, and they have filed it. It has not been addressed yet. But anyways, there was a deadline of January 30th to add additional parties in this thing because they thought the quash motion would be decided by now. And, back in a couple months ago, it made sense you were going to do that. It made sense like, okay, yeah. Why not set a date, this timeline? Well, that timeline is obviously now coming on. But at this point, it's still addressed. Ethan Klein, they opposed the motion to quash the subpoenas. There was a whole issue, and I think we went over this previously. God, it feels like we did. We did. I know we did. It's all been dragging on. Ethan Klein and the Snark mods are going back and forth. They filed motions and counter motions, and it's been going back and forth. You saw there was this and another motion. Then there was a response to that motion. And ultimately, by January 20th, the court said, we're going in front of a magistrate. So you have to tell me if you'd want it or don't want it. We set that for January 20th. And they both consented to go in front of a magistrate. But no hearing happens yet. Like, nothing's been set yet. Nothing's been done. So, yeah, it hasn't been resolved. So, what do? Well, we got to put this on pause. We have to. There's no information when the motion will be decided. And it's unknown whether the hearing on the quash will be scheduled or when the quash motion will otherwise be decided. Because, the magistrate may say, I want you guys to have a hearing. You're going to make arguments. Or the magistrate might say, I want to just make a ruling on the briefs. We also might have to have a pre-order or a pre-motion hearing about all the shit that the Snark mods wanted to keep filing and what's going to be there, what's accepted, or what the scope of what could have been filed already and accepted is. There's a lot of things that could happen. None of it's been done. But anyways, what happened? Denims and Ethan Klein, they met and agreed that if the quash is denied, the claims for direct infringement against Denims and contributory infringement against the mod should proceed together in the present action for the purpose of the judicial economy and to avoid significant duplicative expense. So remember, if Ethan wins this motion to quash, Well, yeah, we should proceed along down the road together. So if that happens and there's a possibility it can, we don't want to have separate cases going. So let's just keep it all together for now. And if Ethan loses the motion to quash, well, then he could proceed to, light Denham's on fire anyway. So they agree if the motion to quash is denied, it would promote efficiency and conserve the court's resources for the claims against Denham's because the snark mods will, you know, I'm sorry. If they do that, they can proceed together. And if the snark mods win, well, they're gone out of the lawsuit and everybody still saves money because Ethan Klein doesn't have to waste resources if he loses. If he loses, he's done. So they agree that, if Ethan wins, it requires a new conference and new reports because now the mods are in the lawsuit. So we'll see what happens. They agree a stay as the present action will promote efficiency. And they want to say there's good cause for a stay. And honestly, it doesn't hurt Denham's. The lawsuit not getting resolved anytime soon helps her because now she doesn't have to lose anytime soon. So yes, 2 more weeks. Yes. That's the problem. The court moves, nothing happens, and then all of a sudden they descend like a thunderbolt. Sometimes stuff happens. It all depends what court you're dealing with. And we're going to get to an example of a case where stuff hasn't happened, and then all of a sudden, boom, something happens, and then nothing. And then we're going to get to one where a bunch of shit happens all the time. We're going to get to that. So what do they want to do? They want to allow sufficient time for the quash motion to be resolved. In the event it's denied, they want to do this all together. And, they want to conserve resources. It doesn't waste time. So they're stipulating. And they want to agree, we're done. We're going to put this on pause. Now, why is this important that it's stipulated? Because if the parties agree that we need to take a break, the court's going to grant it. The court will grant it, and it makes sense. It makes sense that you do it this way. And the court can get around to it. So if you guys are trying to check this out on Court Listener, just so you're aware, this is the place where you can find it, Central District, California. And this is the last thing that's out there really available for you guys to go look unless you're going to go play around on Pacer. Nothing new has happened. So Ethan Klein and Denham's is all on hold. Hold on 1 second, chat. All right, guys. Now, time to yell at Clyde. That's not Clyde. That's Lainey barking. I just had to, because I don't she doesn't know I'm here, I think, sometimes. So she's like, oh my God, where is everybody? It's like, I'm here. And she's like, I'm not alone. All right, guys, the next one here, this one isn't, I know, one that a lot of you cared about or wanted to, really give a shit about. I thought it was interesting because it's an example of a real shitty lawsuit and, involved with a guy who's a complete retard. Stuttering John. You guys remember Stuttering John, the guy who was kind of like the joke and kind of like the goober loser for Howard Stern and, his, whatever I guess he can call it a career or whatever the hell he thinks he's got going on. He is suing Carl from Who Are These Podcasts and Shuli Egger from the Shuli Network because they did, the Dabbleverse. It's basically they exist to A-log Stuttering John. And Stuttering John, acting like a little bitch about everything. They went and as part of their A-logging, people went and stole, well, they didn't steal, but Stuttering John threw a couch out to get rid of it, and people found it sitting in the trash. So they went and, zoinked all the couch cushions and brought them to DabbleCon, which is, the gathering of the Dabbleverse goobers. And they did this up in Rochester, New York. That's where Carl's from. I guess, well, he lives there. He's from there, whatever it is. Anyways, they all came there and they like, ooh, whoa, there's cushions. And Stuttering John, in response to them acting like weirdos, was like, I'll act like a bigger retard. And then he tries to sue them. So he sued them. He sued them down in the state of New York in Manhattan, which is weird because nothing happened in Manhattan. And for those of you who don't understand, uh, why that's an issue about, well, where do they sue matter? Well, remember, you sue somebody where they live or where the thing happened. Those are the easiest ways to get jurisdiction somewhere. Well, the problem is, um, here is the state of New York. It's a big fucking place. A big place. Stuttering John sued them down in New York for whatever reason. And the thing occurred in Rochester. This is like 5 hours drive time from each other. And nothing happened in New York, like in New York City. There's nothing happened there. It all happened up here in Rochester. It's also where Carl lives. Shuley lives somewhere down in Alabama, allegedly. I don't really know. It doesn't matter. It doesn't matter. Obviously, the thing happened here in Rochester, New York. The event happened in Rochester, New York. So there you go. Stuttering John suing them for different things, like they're destroying his name, image, likeness. He's crying about invading his privacy. I think he's crying about everything. Well, Shuley and Carl had filed a bunch of different things, and when you guys have seen, and I mentioned this before, the court docket for this thing was getting out of hand. I couldn't believe how much crap was going on in this case. And for those of you guys who don't understand what I'm getting at here, this is the court case. Like, the number of filings that Stuttering John and his attorneys have filed right now is absolutely ridiculous. Carl and Shuley's attorney has actually done a pretty good job of kind of limiting the damage here. But the amount of crap Stuttering John, anytime you see Benedict Tabor, this is all Stuttering John, like just filing garbage. And this is, we're not, they haven't even really had a hearing or anything yet. Just been a lot of shit going back and forth, a lot of stuff going back and forth. So one of the big things was there was an order to, or there was a motion to say, hey, look, Judge, we're not in the right jurisdiction. How's Stuttering John paying for this? I don't know. I mean, I don't know how many handies you can give to make something happen here. This is a little weird. It's a little weird here. So I don't know how he could do that. So ultimately, I don't know how Stuttering John's doing this. Someone's giving him money. It's the same, these tards and lolcows find a way with these things. It's like Russell Greer. He always finds money. He always finds a way. Do unenthusiastic handies count? I don't know. Stuttering John would have to tell us the answer to that. I don't know. Maybe he's still forced to make eye contact while he's doing them. I don't know. Maybe Stuttering John is just being forced to cry while he's doing them. Whatever the person who's writing the checks has told Stuttering John to do, he apparently is doing it. So what happened? Well, Stuttering John got there was a motion to transfer. A motion to transfer, a change of venue, because remember, you have to have you have to try it in a proper venue location. And once again, you could do it where the defendant lives. In this case, there's two separate defendants, but where Carl, like right now, it's in New York State. So Carl lives in New York. And it happened in a county where Carl lives. Okay, well, great. We have a specific place we could go to. Stuttering John went to the other end of the state for some reason. So Carl and Shuley said, let's bring it to where Carl lives. And Stuttering John opposed. Well, that has been addressed. The court got involved in this one, and it made a filing. This is, like I said, a month ago. Wasn't too worried about it because this is like the only thing that's happened. It's not like I don't know, guys. I can't just do every time like there's a burp on the dock and I go, oh my God, breaking news. Like I can't do that. It's just not. It's like, this is funny, but it's not like the end of the world. Anyways, this motion was filed back on The motion date was September 3rd, and that's back around the time the lawsuit got filed. Carl and Julia were like, wait, 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 we can take care of this. Just send it up to Monroe County, New York. So it's a decision in order on the motion. And they said the following documents were filed. These document numbers were read on this motion for transfer. So they want to transfer this up to Monroe County. They oppose, pursuant to civil law. And this is just the way they do this. The civil procedure rules in New York, they list them that way. And under their law, because it's all codified too. Venue is proper in a county in which one of the parties resided when the action was commenced, or where a substantial portion of the events or omissions giving rise to the claim occurred. And it is. Rochester, New York's where they did DabbleCon. That's where they brought all his couch cushions, and they aired the recordings and all the recorded phone calls and just sat there and A-logged the shit out of Stuttering John. So that's a proper place for it. So in this action, Stuttering John suing under the civil rights laws for using his name, image, likeness, voice for commercial purposes, as well as authorization, common law misappropriation of the name of right of publicity, and for unfair competition. Because Stuttering John's like, it's unfair. You're infringing on this. I could be the only retard out there. It's my market. Now, they point out it's undisputed the only county in New York which any party resides is Monroe County. Stuttering John doesn't even live in New York. And plaintiff alleges that he seeks leave to amend his complaint to add another defendant who resides in New York County. Leave has not yet been granted, and it's unclear whether it will be granted. Now, why is this a bit of an issue here? Well, Stuttering John's already amended he's already amended his complaint. They've already done this. Like, this is not, you remember, you can amend your complaint. You get the one at the beginning of your lawsuit. But after that, you need leave of the court or consent from the other party. And going back to this, we can see, well, we've got the complaint. And then, less than a week later on August 12th, complaint is amended. Well, there you go. That's it. You can't keep amending. You need permission to amend at that point. And that's what they want. But you don't get that. You don't just automatically get it. You have to ask the court. And the court hasn't granted it yet. And the court's like, it's unclear if it'll be granted. Now, why is the court saying, well, I don't know what's going to happen? Well, we're going to get to it because he's basically saying, I can't speak for another court at this point. And they say the sole basis for the complaint for plaintiff's assertion the venue in New York County is improper is that a substantial part of the events or omissions giving rise to the claim occurred here. They say, however, while the claims of the civil conspiracy, and yes, Stuttering John did not plead RICO, which is surprising. They did not plead RICO, but they kind of did plead RICO. They just didn't call it RICO. And remember, in a civil case, it's never RICO. RICO is never the answer at all. At all. RICO is never your answer in a civil case. And if you want to do it, you're a tard. And if your attorney wants to do it, he's a tard. And also, hold on one second, chat. I mean, to be fair, though, yes, they have the Uncle Rico show on the Shuli Net. Like, that's what one of the things where they make fun of Stuttering John. It's called the Uncle Rico show. So RICO is the answer to like that. But in the law, it's never RICO. It's never RICO in a civil context. But they're alleging a conspiracy. Ooh. It's fucking, remember, we went over this. Absolutely retarded. Absolutely retarded. And while they claim there's a civil conspiracy, no such claim is stated. In any event, there is no cognizable claim in New York. And that's good to know that he's basically saying, like, look, that this isn't a thing that exists, which, if your attorney doesn't fucking know what your attorney made up a cause of action or something, that just seems, that's pretty embarrassing. That's pretty embarrassing. If the guy was like a brand new attorney or just moved from another state, okay, yeah, kind of like I get maybe. But this guy likes like, oh, there's a conspiracy. And the judge is like, that's not a fucking thing. It's not a thing. So good job, Stuttering John. You know, the only other identified connection in New York County, remember, New York County is Manhattan. That's New York County. And is the New York City media market the audience for the alleged scheme, which is insufficient, and plaintiff cites no authority to support that proposition. So what are they doing? It's order the change for a venue is granted, and the venue of this action is changed from the Supreme Court, from this court to the Supreme Court. Remember, in New York, the Supreme Court is the trial level courts. Remember, it's not like their highest court in New York. That's the Court of Appeals. In the county of Monroe, and that's Rochester. That's where Carl lives. And it's further ordered the clerk of this court shall transfer the file of this action to the clerk of Monroe County and shall mark his records to reflect such transfer. And it's further ordered within 30 days of this, the council shall move to serve a copy of this order upon the clerk of this court, pay the appropriate transfer fee, and if any, shall contact the clerk of court to cooperate in effectuating the transfer. And they need to coordinate the transfer of this action with the Monroe County clerks so as to effectuate an efficient transfer and minimize the practical reproduction of documents. Basically, if you guys have any paper stuff, it's your, like, we need to make sure we don't just kill trees for the sake of killing trees. And if stuff's digitized, it's even better. It's easier because you just, boop, move over. Including with regard to any documents maybe in digital format. And it's further ordered that the clerk of this court shall be made in accordance with the procedures set forth as far as how things are electronically done. So case disposed, meaning it's he's like, I don't have to deal with this piece of shit anymore. I'm sure he's breathing a sigh of fucking relief, not having to deal with this fucking tard festival. So it's been granted, and he's like, he punted that shit into somebody else's yard. So that's where we're going. If you notice, though, there are no updates, chat. We go to this, and it tells us nothing has happened right now. And we can tell that because we are in the Monroe County Supreme Court. And we are now dealing with, and it can tell you where you're looking at here. You're dealing with the Monroe County Clerk, and this is up the Monroe County Clerk's office up in Rochester, New York. And that is where we are, and there are no updates. As I said, we'll go back here to this, and we'll go down here to the bottom. The service on the Supreme Court clerks, notice of the county clerks, certification of minutes, the assignment of a judge. The assignment of a judge is, we're kind of waiting on that. And then the court notice, nothing else. Nothing else. This is just, it's all stuff we're waiting for. So, like, we have to get this going. We have to get it going. And this is just everybody's making sure the court's like, here are all of us stuff. We're getting ready. So, yeah. The judge is thrilled. Oh, the winner in this right now is Judge Cohen. He's like, get this shit out of my courthouse. He just won. He just won the lottery. So, congratulations. The true winner in this is the judge down in New York City. JCXE says, wow, a month and nothing else. Yeah, I mean, it's not a murder case. It's like, this is gonna civil guy. You guys remember, most civil shit is painfully slow and drags on a lot of times. That's the other problem with a civil lawsuit. You're literally lighting up, as I said, you're taking a pile of money, you're putting it in the middle of the table, and you're going, and you light it on fire. And then you wait like 3 years, and then maybe you get an answer. That's all happens here. So, Ethan does not mind how much this drags out. I'm sure he doesn't. And, sometimes the process can be the punishment. And for Ethan Klein, his case, dragging it out, he's not stressed. Denham's is stressed because it sounds like, where's she getting money? Where's Frogan getting money? All that stuff keeps happening. Yeah, and that's the thing. Russell Greer versus the Farms, that's been going 5 years, and it's still going, and we need to catch up on that because the judge, spoiler alert, denied the motion to dismiss. So Russell Greer is still in the fight. Surprisingly, like, at some point it has to end, but oh my God. But that's where we are. That's where we are. See how the numbers instantly went up? So that's what's going on there. Stuttering John's case is all in stasis. Nothing new has happened. So if you guys are wondering why I did, Angry Cops should go cover it. That would be funny. Send Rich over there. So nothing has happened, and I know some of you have emailed me like, "Hey, are you going to cover Stuttering John and Ethan Klein?" And I'm like, nothing to cover. It's all like, I'll wait till something happens. I don't, I can't. I'm not good at grifting. Like that loose guy or loose or lust or whatever he is. Every time there's like a sneeze out there in the Ethan Klein lawsuit, he's just like, bam, putting out a video. It's like, I can't do that. I can't do that. Like, I just don't have it in me. Like that I'm not good at the grift. I'm not good at the grift. And that's my cross to bear. That I'm not good at this. I'm not good at just seizing on. I can't take a little nugget of nonsense and turn it into, 15 minutes of content. Some people can and they're good at it. And I wish I had that skill. And I wish I had the where I could say like that's something I'm giving a value, but I don't see any value in it. So I don't do it. And that's why we haven't heard a whole lot of these cases. Not with that attitude. Yeah, I know, but that's the thing. Oh. I'm like old school Keemstar. Well, Keemstar's. I don't know if I want to be compared to Keemstar. He had his own trials and tribulations over the years. I mean, that's not necessarily the best. What happened in the pudding case? Which one's the pudding case? I don't know, Bob. I don't know what you're getting at. So the 10-hour quartering segment is incoming. Yeah, well, I don't know how Jeremy does it. I will say, people make fun of Darkside Phil for grifting money, but like, if Phil could grift money like Jeremy could, oh my god, Phil would like he would single handedly be funding WWE champions. Like Phil is Phil grifts a little bit. Jeremy's like, ha ha ha, you are baby. Watch me, professional, and grifting out my car. Everything is under attack. Everything is under attack. My RC cars are under attack. Guys, hear that thump 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 thump? That's Clyde. I wish as I was Keno Casino. I mean, at times yes, at times no. So the I can't grift. Yes, I'm the most honest grift. Well, that's the thing. Keem is always a scumbag. Yeah, well, douche. Keem has always had his own issues to deal with. So I don't know if like being compared to Keemstar was John Will says, what has Jeremy done? Bit himself. That's the thing. So anyway, that's the other thing. Imagine being Canadian. Yes, that's the other part of this. Imagine being Canadian. Like, ugh. There are some fates worse than death, chat. There are some fates worse than death. Now, moving on to the main event tonight, guys. We'll probably get this done probably in about an hour or so. So if you guys want to go watch the casino, don't worry. I'm not going to take that from you. I'm not going to, to quote the Deftones, I'm not going to steal the sky from you. I will not steal the sky from you. But remember, Alyssa Mercante, the insufferable Alyssa Mercante, the annoying games journalist at Kotaku, and their senior editor, which is like, of all the things you could be proudly have as a title, it's like, what, like, it's like a rush hour. It's like if I was a games journalist, and my parents asked me what I did for a living, I'd be like, I sell drugs, Mom. I would rather tell them I'm a drug dealer than being a games journalist. But anyway, she sued Smash JT, and if you guys don't know, somebody asked like, who's Smash JT? Smash JT is a YouTuber and does a lot of other stuff out there on the internet. Smash JT has a YouTube channel here. Obviously, you can find it at Smash JT, and he does comments. He's a former game tester and did a lot of, does like game stuff, but he also is involved in the culture war stuff that are going on out there. Covering all kinds of things. There's AI, there's Tencent, all the stuff going on that's out there. And if the Kotaku dumpster fire, if you click on this, um, you can notice here, you see the name Alyssa a lot of times. Well, he's covered Alyssa Mercante. And going through all of this, you could just, there's a lot of Alyssa Mercante stuff. A lot of Alyssa Mercante stuff. But he covers Kotaku, covers games journalism, all the stuff that's out there that does all this stuff. Now, she sued JT, and I'm just going to call him JT because saying Smash JT is too many syllables at once. But Alyssa sued JT on a couple different theories. The biggest one is that she is suing him for defamation, that he said, because Alyssa has described herself not only as a games journalist, but as I believe she would say she's a former sex worker or retired sex worker. Yes, she's like, I'm a sex worker. I have been a sex worker, is what she says. God, when I say it like that and I'm pointing at myself, you guys are going to clip that. She has proudly proclaimed herself to be a sex worker, which it's like, you do what now? But yeah, she says she's a sex worker, which JT, then she's alleging that JT has said to her, made defamatory comments that she sucks dick. She has sucked dick for a living, which, I mean, I think that reasonable people can imply being a sex worker means you're involved in sexual practices. And, some of that may include sucking dick for a living. I think that's a fairly reasonable thing, but she's suing him for defamation on that. She's also suing him for a couple of things surrounding, really, and this is a couple different allegations, including stochastic terrorism. They're kind of making up a new cause of action here. They're trying to shoehorn in. And it's the idea that JT was basically brigading her, having his people in his discords, and he was using them and coordinating with them, coordinating with other YouTubers to go after Alyssa and harass her and drive her out of her job by screwing with her job. And that was the other thing, was going to be tortious interference in contracts. And then also not only that, but just harassing and targeting her in general. So those are like the main things Alyssa's going after him for. And this is all being done in federal court out in the Eastern District of New York, because that's where Alyssa lives. Now, JT lives in California. And the problem is here, this is all internet stuff. So how do you establish jurisdiction on the internet? Well, JT is represented by Ron Coleman, and they challenged her lawsuit in the complaint on the basis of personal jurisdiction. Because remember, where do you have personal jurisdiction? Where do you have jurisdiction over a party? Generally, one of the places is where they live. Well, JT lives out in California. Well, Alyssa didn't sue him out there. She's trying to hail him into a court in New York City. Well, how do you do that? Well, does he have business in New York? Has he conducted things in New York? Has he done things in New York? No. So if you guys don't remember, we're going to go to this here. Ultimately, in November, things were going on, and the court denies the motion to dismiss for lack of personal jurisdiction without prejudice. It denied the without prejudice stuff here, guys. And this is, I'm not opening every single document, but we're going to go through some documents here. But what happened is the court put this in a unique situation. The court put this in a unique situation for kind of everybody to deal with. What is it allowing? What is it not allowing here? So it denied the motion for personal jurisdiction for the dismissal. But with leave of court, it could be refiled. And here's the part that we're going to focus on now, because this is where we are right now. It can be refiled after the parties complete limited jurisdictional discovery. Now, that means discovery limited to the purposes of establishing jurisdiction. The court gave Alyssa a chance to try to perfect this issue. because ultimately she could always refile anyway. So the court's like, look, instead of dragging us all through that, I'm going to give you a chance to kind of fix this now instead of having to dismiss it and then maybe tomorrow turn around and refile it, or a couple months later refile it when you think you've established jurisdictional proof. I know people were sorry, excuse me. I didn't mean to snort on camera. Or it makes sense. But at this point in November, Alyssa's case is on life support. It's barely hanging on. Um, it's barely hanging on, but she's getting a chance to do this. Um, you keep mixing up Ron Coleman with the bodybuilder Ronnie Coleman. I can assure you, Nightmare Demon, they are two distinct gentlemen. They are two very, very distinct gentlemen. The Dark Side Sandwich Man snort. Yes. So, Days and Catnip says, I have to ask, who are these people? I thought I just showed you Smash JT stuff. And Alyssa Mercante, you know, she's the former senior editor at Kotaku. And that's where we're doing that. But anyway, they're doing this limited jurisdictional discovery. Limited jurisdictional discovery. Okay. So they're going to work on some stuff here. They're going to work on some things. And as we scroll through this, okay, so, you know, we get past Christmas. They are going to, you know, they want to issue some subpoenas. And some subpoenas are going to come out. And there's a motion, you know, in order for they're going to propose subpoenas that were going to get issued. There's some stuff that, you know, they're trying to find out what's going on. Who, you know, how do we establish? Is there enough jurisdiction? Did this stuff get planned? Are there any ties to this occurring in New York? Are there people in New York? Did anything we could use to tie this to the state of New York, in particular, the Eastern District of New York? So what do they do? Well, there were some subpoenas issued out. One of them is to Discord. They're doing one to Discord, and they're trying to get basic information from Discord at this point. So they want Discord's, you know, they want Discord information. And this is where, you know, stuff that happens in a lawsuit, guys, you know, people were freaking out about this. It's like, if you do stuff on the internet, everything is recorded. Everything is documented somewhere, and it can all be discovery. So they want each incurred former member of the Discord bearing unique IDs to the Smash JT Discord server. So they want their ID, their name, their phone number, their email address, their billing address, which, you know, there might not be a phone number, but there might not be a billing address. But if there's an email address, you know, just look at the forums. You could do a lot with an email address. Last access IPs. Whether they ever boosted the Smash JT server, the date and time they joined, the date and time they left. All this information they want because they're trying to see, can we attach this to the state of New York? Can we tie it to New York? Discord DMs aren't even encrypted. Well, it doesn't matter if they're encrypted because Discord's the one encrypting them. So, yeah, it doesn't matter because they can still turn them over. Johan says this isn't reason to stand up a private Ventrilo server with no logging. Yeah. Well, there's that too. Those are options as well, but I mean, guys, yeah, that's the thing. And ultimately, Smash AT can't oppose it, really. There's nothing to oppose. It's not like his information, it's Discord's information. So it's not even being requested of him. So, like, you know, people were like, oh my God, how could he? Like, what did you want him to do? Like, people were upset about that, but I'm like, I don't know what you think is gonna happen here. So they're gonna ask for it. So that's kind of, you know, what we're dealing with and how this works. Now, as this case starts progressing, while we've all been busy in the early parts of the winter here in the heart of winter, things start happening. In December, there was a motion to compel. There was a motion to compel. And what was that motion to compel for? Well, the motion to compel goes back to the written discovery of things that were requested. So through Alyssa's attorneys, uh, the esteemed firm of KUSK, the Lolcow Scooteria, as it were, and also the Remy Cohen firm. Once again, lawsuits involve lawyers. We get to this. They are pointing out, and remember, guys, this is in federal court in the East Coast. Things are done via letter. Consider this a motion. Okay. Anytime you see these things, consider the motions. That's what you're looking at. So they write to move to compel discovery, and they say, as of today, despite serving document requests in August, there's a grand total of 2 documents. So they want to get things moving. And they say they want to point out, Judge, you said jurisdictional purpose wise, we want to know the extent of the relationship with New York based content creators. Because JT has been on with Hypnotic. He's been on with Toasty with the Mosty, and also Rev says Desu. Okay. They want to show, we want this information. We want this information. And they want that. They want that. So accordingly, we need to get some stuff here. Now, what is this? So for context, it's all about JT's well, here's some things that JT has a website. His website's interactivity and business conducted with the New York and New York residents. I don't know, and this is the one thing where some of the stuff they're requesting is stuff JT doesn't have. Like all that stuff from Wix, you're going to have to subpoena Wix. That my personal website for my law practice is hosted by Weebly or Webly. If you wanted like the coding or any of that information, you'd have to contact Webly. I don't have access to any of that. I have only access to the UI that they give to everybody. The revenues through his website in terms of subscriptions from New York residents, I don't know if JT has any of that information. He would just, money comes in. Like he doesn't necessarily know who they are or where they are. Maybe he has emails or something, but that's about it. But you wouldn't necessarily have any billing information. Not always. Now, if it's done through Stripe, that can be out there. And that's a thing, chat. If you have Stripe, if you know content creators and they're using Stripe at all, Stripe, you get access to all kinds of credit card information, just like your regular company. Like your coffee shop or a car, muffler shop, or in Phil's case, a sandwich shop. You have access to all that credit card information. So be careful. If you deal with a creator, like they're using Stripe, they could steal your credit card data really fucking easy. Like it's all right there. It's all right there. So Weebly, nerd, or Webly, whatever you want to call it. They said, they also want the extent of JT's relationship with these New York-based content creators. And any further connections with the defendant with JT's website, his Twitter, and the YouTube have with New York and New York residents. So they said, and even as served, JT produced only 2 documents, a spreadsheet covering information about his donors to his Give Send Go litigation, and a printout of the website source code. And they met and conferred, and they said, what are we going to do here? They also asked Planet to send a detailed deficiency letter back when they meet and conferred, saying, what do you want? With details about why some of plaintiff's claims that no responsive documents existed were wrong. And that's the thing. They said no responsive documents exist, so they could review. They said this all occurred on December 10th. And they're claiming that, we promptly served a letter. And the response did not come as agreed on December 7th. And then on December 17th, Alyssa and her attorneys asked for another meet and confer, which they met again on December 19th for approximately 20 minutes. At that meet and confer, this is between the attorneys. Ron, because when I say Alyssa, I mean Remy Green and whatever the fuck's that other guy's name? The fucking cuck scoober. Lane Haygood. And then when I say JT, I'm talking about Ron Coleman. Where it says defendant, that's Ron Coleman. Ron stated he intended to make some supplemental production, and any communications would be a very limited subset of what exists, even with Hypnotic, Toasty, and Rev. And that he understood that they would be disappointed with the production. And that's the thing. You could say, look, here's the limited stuff that matters. Because let's say there's stuff in there where they're sharing cat memes or whatever. Then you could say, well, that's not relevant. But you know what? Like sometimes if you turn it all over, fine. But then if you turn over everything, if they're talking shit about Laser Fist, remember all that stuff gets brought out into the light at some point. The parties also discussed the substance of the objection, which the defendants claim was that documents also had a substantial role in litigation were off limits. And that's the thing. Some of this stuff, they're like, you're asking for stuff that actually goes to the matter of the actual claims in the lawsuit, not jurisdiction. So they said, we were at an impasse, and to keep discovery moving in light of the deadline, they want this motion made, so they want to compel. Now, we're not going to go through all the things here, but, basically they want this stuff here about Hypnotic, Toasty, and Rev. Okay. So here's some things that have happened. So this is a request. And we're going to go through these just real quick here, just so you guys can see some of the stuff Alyssa has requested through her attorneys. This is a first set of written discovery, and we're not going to go through. We've done all these before, guys. We've done this. This is all boilerplate stuff here. If things have been destroyed, you're asserting privileges, all the definitions. We're not going through all that. We've done all this stuff before. But notice some of the stuff they're asking. You can already see, like, what are they asking? What are they going to get at here? So they're asking stuff about the Give, Send, Go. They're asking about the Tiwi Farms super chats. So what are they asking for? They say, please provide any documents you have authored, received, or otherwise in the custody concerning Kotaku Detected. Now, Kotaku Detected is the whole thing of like, this smells like journalist. It's like, the, retard alert there. Please provide any documents you have authored, received, or otherwise have in custody concerning the lawsuit. They're asking, and that's where you have to go back and read the definition about what they want there. Provide all documents considered Jordan Nowotny between March 1st and today, especially communications between you and Nowotny. They say, please provide all documents concerning your super chat earnings. This one's a little weird because the documents regarding your super chat earnings, and this is where I don't think Alyssa's on YouTube, but in your YouTube dashboard in the Creator Studio, your analytics and you're earning things. There's not a whole lot for you to look at. And I'm just going to show you guys a little bit of a thing here. There's only so much you get from, what goes on here in your, you could show here. I mean, this is an example, and I'm going to show this because it's nothing sensitive's on here. But this shows, like, this is all you have. I don't have a breakdown of a lot of information here on your super chats. Like, I get who sent it and what you sent, but you guys already can see all that. You guys already know what's happened. And some of these, like these ones here, like this is the line. These two are from today. All this stuff here is from last night. And you can get a scrolling list, but it doesn't show anything else. There's nothing else there for you to look at. So I don't know what documents you can get from a super chat because YouTube processes all the payments through Google. I don't have access to what's been provided there. So I don't know if they properly expounded upon this, but some of the shit they're asking for literally is fucking impossible. Why can't they download the YouTube video on their own? Because they're asking for documents. I'm sure they're downloading stuff anyway, but they are allowed to ask for it. and if it's something that can be provided, you have to provide it. Plaintiff will accept as sufficient any document that breaks out super chat earnings on a per stream basis. There's no documents for that. Now, here's the thing: you aren't expected to create a document. There's no document which you're requesting here. I don't have any of that. Like, I'll show you and I don't even know how far back I can go in super chat earnings. It's a very limited thing. It is not the YouTube Creator Studio doesn't give you a ton of access to everything. Like, a lot of this stuff I think is going to be within Google's knowledge and per knowledge there. I think they're going to be a little tough on that one. Ultimately, they're asking for a lot of things here. I don't think they can do. I don't think they can do in this regard. In that, I'm flashing his back end again. No shame. But you guys haven't seen. If you guys aren't creators, you haven't seen it. You don't. If you're not a content creator, if you guys have never seen YouTube Studio, that's all it is. We don't have endless data here. Please provide full resolution video of all YouTube shorts, reel streams, or other online video communications that feature JT concerning Alyssa Mercante or the subject of the lawsuit. It's actually, that's not as problematic as it would normally be. But yeah, you're going to have to download all your stuff because, guess what? Like, I don't save any of my stuff. It's all uploaded to YouTube. That's where I can find it. Nobody, you can't afford to save all this shit hours and hours on end. All written communications between JT and other YouTube, Twitch, or other social media influencers, streamers, or content creators concerning Alyssa Mercante and Kotaku or the lawsuit. Please provide documents concerning Kiwi Farms, especially communication between you and any member of Kiwi Farms. Please provide all Chat GPT. And this is something here, which reading through some of the later issues, Chat GPT, Claude AI, or other LLMs prompts by JT or somebody on his behalf concerning Alyssa Mercante and Kotaku or the lawsuit. From what I understand, JT has been on stream before talking to fucking Chat GPT or Grok about the fucking lawsuit. And it's like, holy fucking shit, you guys. Do not do that. Number one, that's just retarded and it's cringe. Well, it's retarded, cringe, and gay. So that's a big number one. That's a big number one. Don't do it. Is Bonbon streaming now? No. Yes. Don't do that. Don't fucking do that. It's cringe. I don't care who you are. If you're sitting there on Suno or whatever the fuck, and you're making up gay, retarded AI songs while you're chatting away with people, all that shit's retarded. But also, that's all documented. So if you're doing your own self-legal research, don't do that. Don't fucking do that. Don't. Don't do it. Don't do it. All right? There's, and it just keeps going, though. Like, all the stuff that they wanted. And this gets us back to where all the discovery problems have gone on. Financial records from Giz and Go. All records of income from your YouTube channel from March 1st to present. Depending on the situation, you might be able to show that. But, for YouTube, when you look at your analytics, it goes on a year-to-year, after you get, I'm just hold on here. Let me look at mine. How far back can when I break stuff down? Oh, here's the thing. When you're looking at, YouTube revenue, you can look at your last 7 days, your last 28 days, your last 90 days, your last 365 days, lifetime, 2020. Now I'm limited to 26 and 25. But obviously, I've been monetized longer than that. But you could try to do a custom time window, but it's not always the best. It's not always the best, chat. It's not always the best. So, Hydrosphere says, wait, did he lose? No. But he's not doing himself any favors. J-Rock says, how does any of this establish connections to New York? None of this will, because even if people from New York are sending him super chats, this doesn't help Alyssa's claims because you need a lot more. It's extremely tenuous at best. I mean, this discovery is not going to get her what she wants, I think. Unless she can show that the discussions with people from New York, like there's clearly like they said something and did something retarded in their DMs or emails. Any records of income from the Smash JT website, all documents concerning paywall revenue from the website, with sufficient information to determine the state from which any revenue originated. How do you know he's going to have sufficient information? Like, he might not. All records of any income from other sources from March 1st to now. There's stuff here I would object to and say that's not relevant. Like, I'd object to this. But some of these documents showing, like, what state is this coming from primarily? Like, if it showed like it was like 99% from New York, okay, fine. But that's not the situation here. You know, all written electronic communications between you and anybody you've consulted with regarding your social media presence and strategy for dealing with Alyssa. All communications between you and any persons other than attorneys or experts who have consulted with you regarding this lawsuit and legal strategy. All documents you're referring to as proof in your YouTube live stream. I need money. I just do. From July 16, 2025. All documents concerning the matter of subject matter personal jurisdiction, you and your counsel's disclosed advice that summoning someone from across the country happens all the time. Now, some of this stuff, I think, like, this is grasping here. This is grasping. I'm not worried of, like, they're allowed to talk about stuff, but this right here, not going to really work. It's not, like I said, none of this is going to help. But the problem is, when you fuck around in discovery, we're going to get to the problem that happens. And we're going to get to basically the end of the conclusion here. Provide all documents concerning the subject matter of your counsel's disclosed advice and opinion that he felt like there was something greater at play here and that they have nothing here. Now, see, like this stuff, you're not going to be able to, like, I could say that you have nothing, as an attorney, and that doesn't mean you're entitled to work product. But yeah, there is something greater at play here. This is, Alyssa's being funded. Like, I don't know if Elliot Fong is involved in this, also known as Liz Fong Jones, or who is, but I can't imagine Alyssa just supplied the money for this on her own. I don't think she has any money. The documents concerning your counsel's disclosed advice that he thinks is going to get tossed out. So do I. I think at the end of the day, should. And this is what's more horseshit here. Any and all documents concerning possible defenses you might raise, assembled by you or your counsel for use in drafting any present or contemplated filings. Once again, not happening, definitely. This shouldn't happen. But you ask for it. Fucking ask for it. See what happens. All documents, now this is the thing here. All documents you intend to use at time of trial for impeachment or demonstrative purposes. Well, I don't know what I'd be able to use for impeachment until the end, and I could argue I don't have an obligation to show you impeachment purposes. So once again, you'd object to all this, but, they ask for it. It's your duty to object to it. It's your duty to object. So you can ask for it, and you might say, fuck it, I'm not going to give them that. That's work product. If you don't object or you don't object properly, they can now say, Judge, they're not following the rules, and the judge could sanction you for it. So that's why you have to say, get the fuck out of here. I'm not doing that. Some of this is just nonsense. So there was the motion to compel. And ultimately, the court ordered a motion to compel. And we get back to what's going on here. We get back to this. There is stuff that kind of chugged along. The case kind of dragged. And ultimately, the court ordered the motion to compel. And there was a motion to compel. So the court says, start producing fucking documents. And what it say? Produce all documents responsive to the document request. And it says that you may obtain any non-privileged material that is relevant to a claim or defense in proportion to the needs of the case. So They point out that courts have a broad latitude to determine the scope of discovery. And they say here that it's jurisdictional to determine the extent of the relationship with New York-based content creators. So that's where if I was Ron, I'd say, look, fine, you want that, great, but I'm not giving you super chat information. I'm not giving you information off the website. You want to use these people and claim you colluded with New York-based content creators who live in the New York City area, then use that, and that should be limited to here. So, now here's the thing, though. And the judge is determining that the information, such as the interactivity, which, okay, but the revenue amassed from New York residents lies within their knowledge, and thus they're entitled to learn these facts. I don't think it's within their knowledge. I don't think, like, the idea that you have access to all this information. Like I said, I don't have access to any information about you guys from your super chats. I have a screen name and how much you sent. That's all I have. So, they point out, in addition, though, the defendant's objections to the request are insufficient to exclude discovery of the requested information. And they point out here, and the judge points out some things that have to be considered when you're doing an objection in discovery. And remember, like I said, guys, in discovery, the way you object can, make or break things. Objections must state whether any responsive materials are being withheld on the basis of that objection. So you can say we object and we are withholding material. An objection to part of a request must specify the part and permit inspection of the rest. So you might ask me for a set of documents, and I'd say, I'll give you, out of the 5, I'll give you 2 of them, but I'm keeping 3. I can't just say I'm blocking all 5. If 2 of them are compliant, I have to let you see the 2. And then we could go to court and argue over the 3. And the motion, JT is opposing it because information is being withheld because JT has informed his counsel that all his communications with the relevant parties are extremely voluminous and have virtually none or perhaps none at all are relevant. Well, that's for the other party to get to look at, well, what's relevant. And yes, the conclusory statements of being burdensome are not enough to defeat a relevant discovery demand. So what does that mean exactly? For example, in corporate discovery, there are going to be times where you've got stuff that are backed up on magnetic data tapes, or it's like that thing you're asking for, that project this company did is 25 million documents, and it's 500 terabytes of information. That's voluminous. Okay, well, you have to describe the volume or the cost for production. You have to state why. And, you might have to say, fine, but you're going to have to pay for it because if we pay for that, I'll go broke. So, what did somebody say? Use green? What? He didn't fail to object to it. It sounds like they objected kind of like they kind of did the bare minimum objections in some spots. I don't know for sure because I haven't seen the actual, we don't have everything. Remember, part of this is obviously these parties are here. I assume that they're not completely lying about every fucking thing, but they might be. Who knows? We don't really know at this point. So there's all kinds of shit that's up in the air here. All right. There's all kinds of shit that's up in the air as this is concerned. And we're going to get to all this stuff here. Well, now here's the thing, JCX. So you're bringing up a point of, so I download the videos and could Alyssa say, well, these aren't 1080p. No. I mean, can you figure out what's going on them? Then fine, you go download them. 720 is acceptable. 1080, that's what you have there. That's what you have there. There's nothing else you could do that. Hold on. Does this establish connections in New York? Yeah, well, some of it does. Not all of it, though. A lot of this is a fishing expedition. A lot of it's a fishing expedition. They could be that petty, but that wouldn't be an effective grounds to complain. So, Now here, like they cite a bunch of different things if you guys want to read it, and they say although and here's a case even where it happened where you're dealing with ESI, electronically stored information. If you say that it would be unduly burdensome, you have to explain why. And it says, simply put, they haven't provided enough specificity to prevail on objections. So, oh my God, what is wrong? Like, this is like in fucking delay. Ooh, ew, 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 ew. Okay, so let's try this again. The defendant has not provided enough specificity to prevail on objections. Yeah, if you don't specify enough, the court's like, I can't work on it. And then it says the court defers ruling on whether sanctions are appropriate at this time and will consider whether sanctions are appropriate after resolving these motions to compel filed by the plaintiff on January 12th. Now, here we go. Here we go. This is, if you don't comply with discovery, you face possible problems. And one of them is a sanction. Sanctions can be monetary, or sanctions could be a lot of different things. One of the things a sanction can be, and this is where the defendant's being warned. I'll move my image to the other side. Sorry about that. Sorry. Defendant is warned, however, the continued failure to comply with discovery obligations will result in the imposition of monetary sanctions pursuant to Civil Rule 37. This is on January 14th. So we kind of got something here. If you don't comply, the court's warning, it's not saying it will. It will result in the imposition, but it's, is that a threat? I don't know. We don't know yet. Remember, this is still January 14th. Well, as we keep going here, there is there's a bunch. Sorry, we're scrolling past that because it's like duplicates in there. There were consent motions filed to extend time to file responses. They had a February 2nd jurisdictional discovery cutoff. As things go here, they go and go and go and go. There were, we're opposing the times here. Then we get to what happened in January. There was a telephone conference that was held. And then from here, there was a consent motion ultimately to complete discovery that was filed in January on the 26th. The court deferred ruling and addressed things here at a motion conference on the 9th. So the court noted there was a motion hearing and a motion on the motions for discovery. So this is where things start happening that are, well, I'm just gonna, this is where it starts getting interesting and actually things matter. We get to the we cut to the chase, chat. So this is the telephone conference they had, and they had a telephone meet and confer, and it's open court, so people were there to hear it. And this is where, when I saw the somebody had done some AI stuff, went, oh my God, Ryan Coleman had a big crash out in the middle of it. I was like, I find that highly unlikely. Well, it turns out that was somebody in my Discord who went and listened and took notes. And I don't agree that it was a crash out, but certainly, like, yes, it sounds like people were passionate in their, Ron Coleman was being passionate and how he was doing stuff here. So I just think it's funny because Ron Coleman filed this letter with the court, because he said he thought it was, I thought this was going to be a private thing, but it's like, no, it's court hearing. So people are allowed to attend. And yeah, most places it's open. So plaintiff's counsel responded, but said they expected third parties to dial in, which is normal. It can happen. He thought it was going to be an in-chamber style magistrate conference. Sometimes it happens, though. But anyway, says, based on information from plaintiff, a non-party who operates a YouTube channel and is active in online discussions concerning this case did evidently dial into the call. He didn't identify himself. Now, to be fair, Chad, I was not there. I was in fucking court on the 9th. And then said shortly afterwards, someone produced and uploaded this non-party to this non-party attorney's Discord server. Yes, mine. God damn it. A summary of the conference that bears the clear hallmarks of audio transcription, polished by an LLM. Well, yeah, no, it's just the person took pretty good notes, and then obviously they fed it into the AI and put their spin on it, and the AI produced the information. So the summary circulated elsewhere and became the source of considerable online abuse affected. And here's the problem. This is the one thing I don't. It doesn't matter. I've been involved in a case now where one of the people went online and all they did was shit on me and talk shit about me. But you know what? That happens. You have to deal. If you're the attorney, oh well, you have to deal with it. I get it if you're defending your client, your client shouldn't be getting disparaged. Okay, cool. But if you're the attorney, regardless of who you are, you shouldn't be fucking crying about it. Who cares? When you on both sides of this argument, people are going to look and say Alyssa and the lolcows will never do anything right. People are going to be like, Ron can never do anything right. But the idea that you should be worried about, you're getting online abuse, it's like, buddy, you're the fucking attorney. This is the one thing I will say to Ron, and I respect Ron. He's a very smart man, but it's like, any of these lawsuits, we've covered these lawsuits. When the attorneys start fucking crying, that's never that is one of the things you can't do. You never file RICO. That's one of the big things. Don't ever file RICO. And if you're the attorney and the other side's causing problems, you can bring it up in at a conference, maybe. Your Honor, can you just have them stop? But otherwise, in the filings that you're getting shit on, oh well. Oh well. You can't do that. I think this is a poor, I almost there needs to be a what to do as an attorney if you're involved that you would take a case where it's all in an online shit fight. And one of the things is get prepared to be made fun of and just fucking deal with it. It's going to happen. You're going to have to suffer. If you don't want that, don't take the case. So, Buck says, if you can't handle criticism, you shouldn't be an attorney. No. But the criticism from the general public, think about it. This was just a case on the news. It's like Johnny Depp and Amber Heard. You're going to get shit on by the other side and the supporters from the other side. And if you don't like it, don't take high profile stuff. Don't take high profile stuff. I mean, that's just that's more of my point. Was the attorney trashing you online, J-Rock? No, it's not it wasn't an attorney. It was the other party. It was the opposing party themselves were talking shit. And it's like, you deal with it. You just fucking ignore it. That's what you do. I mean, because to be fair, Buck, and this is not picking on you, just bring it up. For example, if I'm the attorney in a divorce case, the other side and their family's gonna fucking think I'm a bad guy. It's like, yeah, deal with it. So, ultimately, that's the thing here. So, going through all of this, Ron just brings up he thought it was somebody who recorded it, and ultimately, but anyways, he went to court to take note of the incident, and and I wasn't really worried about the rest of this. This stuff right here is kind of important, though. Once again, if you're an attorney and you're worried about people fucking mogging you, man, it's there's nothing you can do about that. Nothing you can do about that. Yeah, this is true. This is a lawsuit at the end of the day. And the lol cows are the parties. Alyssa's a lol cow and JT is a lol cow. Lol cows are involved in lawsuits. And you could be the best attorney in the world. You can hire Paul Clement to be your fucking attorney. And guess what? People are going to say Paul Clement's an awful fucking attorney, even though they have no idea what the fuck they're doing. If JT had hired fucking Alex Spiro, the guy who defended Alec Baldwin, you know how many people on Alyssa's side would say, "Oh God, that guy's fucking awful," or if JT had hired Brian Steele, the guy who basically ran the table in the Young Thug trial and fucking beat the shit out of Fannie Willis in the prosecution. You know, people would say he's fucking awful. He's probably one of the best trial attorneys in the country. Or Alan Jackson, who defended Karen Reed. Like, everybody's going to say you suck. Like, that comes with the territory. Comes with the territory. You got to deal with it. Got to deal with it. So ultimately, we keep moving on from here. And the court takes care of things, and it says that, you know, they responded to the motions. And the court says, like, look, there's another motion to compel. And what happened? There was a motion for Rule 37 fees until the resolution of jurisdictional discovery. Once again, we're waiting. We're waiting. And what happened here? The deadline to complete discovery was extended to February 17th. February 17th. Keep this in mind, chat, because here we go. Here we go. We get into the heart of where we're at right now. Okay. There was a motion for a protective order, which, okay. And then Alyssa's attorneys actually did file, like, this is actually, somebody asked me, is this like wrong or incorrect or not? And I think this is proper. They filed a motion or a notice to the court, like, do you want a response to the apparent motion? Because remember, that thing Ron Coleman filed, that letter, is technically a motion. So they put something out there, and if you're not sure, and there's nothing wrong with asking in the court, like, are you asked, like, do I have to respond to this? Are you asking me to respond to this? Like, this is actually proper lawyering. You point out, though the letter purports to seek relief, is only filed as a letter on the electronic filing. And though it cites the court's remote protocols and all of that, plaintiff would just ask the court whether a response is required at all. And if so, give me a little bit of time. And in an abundance of caution, we provide some discussion below, either viewing the letter calling for a response, or if you want us to give any more context. And basically what happened here was, Judge, I don't know what you're doing with this or what you're thinking, but if you do decide you need a response and you're not going to give me time, then here's a response at the bottom. So, like, that's the issue there. That's the issue there. And they do, and they provide basic information here of, like, look, here's our understanding of all of this. And this is the funny part here. The subsequent information that got revealed as this is concerned, and this is where, as a non-party attorney who operates a YouTube channel, but in subsequent communication, they appear to agree they have misidentified the speaker reporting on the case as if we were the owner of the Discord, and the person commenting was not the attorney. And I had reached out to Ron. I was like, hey, just, so you know, that's someone on my Discord, not me. And I guess very quickly, Ron and Alyssa's attorneys figure that out. But I clarify that just so they know, because it makes sense. It makes sense to do it that way. So, like I said, I wasn't worried. Like, if I got to ended up with a subpoena, I'd be like, fine, subpoena all this shit. I don't care. But I just was like, you guys, like, I'll save you some time. That's not me. So that got addressed. But, that's proper lawyering. Somebody asked me if that's wrong. Not wrong at all. If you don't know what the court wants, ask. And the court might say, I'm not in charge of that. Okay, fine. But you deal with it when it happens. So there was a transcript of the proceedings, which, yeah, that was not things are not looking good at this transcript. And we're not going to read the transcript because I don't want to do that all fucking night. So there was a status report by the 17th. And here's where we get to, where are we at today? Where do we go from here, guys? Because this is where things start happening. And this is just a simple thing here. and this is, we'll talk about it. We'll talk about it. What this is at this point. Oh, I don't want that on ultimate thickness. I want that like this, and then opacity up. Sorry. You have to, every time you open a new document, you have to reset these things. So, at their things as their status conference, ultimately the court said, how much time do you think you need to comply with all of these requests? Making sure to clarify that gives you both time to meet and confer, as we discussed as well. So not only give all the shit they're demanding, but also if there's any issues, you guys can sit down and talk about it. How much time are you going to need? And it says, remember, because they had set the date for the 17th. Okay, well, today is the 17th. So it says Ron reached out today with an update promising a large production that would begin tonight and is expected to be completed by no later than Thursday, close of business. But no documents or updated responses have been produced since the conference. Otherwise, here's the current status. They talked about the meet and confer. And Alyssa's attorney said to JT, let us know when you're available to meet this week for the meet and confer. The court directed us with screen sharing. It said Ron didn't respond until earlier today, and it says later in the same thread, after Ron raised the issues he described, they sent a reminder that we hadn't heard things back. And that's actually something you'll do as an attorney. You'll say, hey, man, what are we doing? What's the game plan? And it says during a phone call today, Ron offered to schedule a meet and confer at some point in the near future. Accordingly, they haven't had a chance to meet and confer. The court order to take place before today. And it says today, defendant offered to be available on the 18th, that if the court grants an extension, the parties will meet then. So notice they're saying, Judge, we need to figure out what's going on, but we haven't had a time to do it. And then from here, they say that defendant has not made any production of direct messages and communications. They expect it will be completed by the close of business on Thursday. The give, send, go information. This was proposed with an attorney's eyes only provision. And that's important. Why is it eyes only and it's protected information? Because guess what? Alyssa can't go run around and put that shit all over the internet. Everybody who's giving her money, here's their email addresses, go get them. Because that's something she would fucking do. And to be fair, that's all what some of these fucking communists want to do. That's what they do because they're revolutionary communists and shitbags. Well, if that all comes out, Alyssa and her attorney could be sanctioned. So they have to stop. They can't do it. And it says defendant has not made any further production, but today made a representation that further production is forthcoming. And then it says the Wix backend code and subpoena. And this is where it sounds like they sorted it out, because when you read it at first, it's like, if they want to enable subpoena for Wix for their backend code that he can't produce. Defendant did not respond, so plaintiff served subpoena on Wix without stipulation. Wix responded indicating it had objections that would be resolved by a stipulation. So defendant signed a stipulation today, which plaintiff immediately served on Wix. I still don't think Wix is going to allow that because it's proprietary stuff that, who knows? Who knows? The chatbot transcripts. Defendant has not made any further production, but today made a representation that it's coming. Super chat documents. Well, once again, I don't know what they're going to, the defendant has not made any further production and represents they're not in possession of any responsive documents. I agree. I mean, there's nothing you have there. Like, how do you do this? Like, there's literally nothing. Like I showed you guys, I don't have that stuff. So from here, they point out that this thing from here, the court talking about the letter, about the non-party being involved. The court's like, I'm not worried about this. The courts in general, they're open to the public. Ultimately is what the court says. Like, I'm not worrying about this. Now, we're just not dealing with it. We're not working on that or doing anything here. So what are we getting to here? Well, things have come and gone, and we get to motions for sanctions. And this is where things start. This is where things start getting out of control. J-Rock says, why'd they move for protective order? They did already, but Just joined, but Nick just went live to blow the cover of the undercover I DM'd about. Yeah, I saw that, and I understand that messed with the filings, but I figured we were going to watch that tomorrow. But yeah, apparently there was like an undercover that came on, and I don't know. Oh well, I mean, I don't fucking care. It's like an undercover might get blown. Like that's Safa undercover. Like that's the state's fucking problem. Besides, he's a cop. He has a fucking gun. Deal with it. You know. Clippy says Alyssa's attorneys are asking for things that JT does not even have. But you know what? You need to show I don't have that thing. But they're also asking for stuff he does have. And if you have it, you have to give it up. But if they're asking for stuff you don't have, you make it clear you don't have it. There's yeah, I mean we're gonna get to the issues here. We're gonna and the bigger problem is we'll get to what the biggest problem is here. So there's a little bit of editorializing here, but when you're in this position, they're acting like they have the high ground, and they kind of do right now because they've asked for stuff and it hasn't been provided. It hasn't been provided. So yeah, and I heard the Court TV nuked all that stuff, but we'll watch that tomorrow, guys. We'll catch up on day 4 and 5 tomorrow. So they point out that they're saying that they're baffled, but are they really baffled? Who knows? Like I said, this is all stuff that's not going on in documented form. They asked the court to impose sanctions pursuant to Rule 37 of the civil rules, otherwise issue an appropriate order to give disobedience of court orders. As set up below, defendant is simply not comply with the court's orders. And she's, they say, given what's going on here, Alyssa's like, I'm not going to tell you all about what's happening here. So they point out after granting in large part motions to compel, the court asks defendant, how much time do you think you need? And this is where the judge says, if I said a week, I want it to be a week. I don't want everybody coming back and then we need more time. And this is something even I fuck up once in a while. And I've learned how to deal with this. Like, you tell a judge, like, look, can you do it by this date? If you can't, you just say to the judge, no, I'm going to need more time. Now, the judge may give you that time, or they might say, judge, say, tough shit, we're doing it this day. But generally speaking, if you ask the judge for that more time, you just do it. And the judge say, okay, fine, I'll give you that time. This is a thing, especially like, just tell me what it is you need and how long it's going to take. But they point out since that time, there has not made any further production. And they say, rather than making productions over the course of last week on the final day, after the promise of self-imposed deadlines to comply with the request within 72 hours. And this is the thing, Ron, like, it sounds like Ron made a bunch of like, I'll promise to do this, I'll promise to do this, I'll promise to do this. No, like, sometimes just say, look, I don't have an answer right now. Give me extra time. If you're going to say it's going to take me 3 days, well, then you're kind of saying it's going to take you 3 days. So, they point out that, all discovery had to be done by the 16th. On the 17th, defendant provided an update promising a large production that would begin. And he was expected to be completed no later than Thursday by close of business. And now, obviously, they point out here, this letter was obviously drafted before because they anticipated it. But given the long pair of deadlines, we were unfortunately confident nothing would be produced. Honestly, if I was in their shoes, I'd be ready to file that too and have it ready to go. I would have that ready to go too. That's actually fair. That's fair. And it says, because a letter was due per the court's order, meaning we had to give a court a status update, the parties discussed and prepared a joint letter. In both email correspondence and during the update, the parties discussed the defendant would be filing for more time, albeit one out of the time allowed for such motions allowed by the court's rules. And once again, the rules will make or break you. But you notice that you're like, fine, I'll give you more time, but I don't think the court's going to grant it. Well, here's where we are. So the defendant is making a motion to extend the time to comply and the end date for jurisdictional discovery compliance. The letter made certain things contingent on that, and it said the court grants the extension, the parties will meet. And accordingly, they included in the motion things rules saying, per our call, here's our position to include asking for more time. But the defendant did not make any motion. This was consonant with his attitude towards the court orders before the meeting. And this is where the plaintiffs or the defendant said in response to the plaintiff noting, and this is where Alyssa's attorney said, hey, this judge requires extensions quite a bit more than 12 hours before a deadline. Yeah, that is a bit of an issue. And it sounds like they know because they deal with this judge. It sounds like they know that answer, like they're speaking from personal knowledge. And that's the thing. If you're an out of state attorney, or let's say you're an attorney from the other side of the state, or let's say you're in county A, there are a lot of times where attorneys who are in county A never come to the next county over. That's not uncommon, especially like attorneys who are in Cleveland. Like that's an entire ecosystem. If they come out to the suburban and rural counties, doesn't always happen. So I've had cases where you deal with the attorneys who are in Cleveland and they come out to, a suburban court or a rural court. And I'm like, hey, here's the lay of the land. But Ron says here, he says, well, we can write to the judge. I'm not worried about that. Well, sounds like maybe you should have. After a sponsor plaintiff expressed that she did worry about Alyssa complying with the court order, he said, yeah, I'm not worried because we'll write a letter updating the court. It's going to be awesome. Now, yeah, there's sometimes you say, fuck it. We'll just write we'll write an issue and be done. Yeah, but we're already into like a couple of motions to compel and the court's kind of already getting pissed off. So this isn't just like normal discovery. We've already had motions to compel. The court said you aren't doing what I need you to do. And they're saying you weren't very specific in your objections. So this becomes an issue now. If it's like, oh, everybody's happy and hunky-dory, yeah, you could do that. And the judge would probably be like, yeah, whatever. You guys work on it. No, the judge is like, I've had to get involved now a couple of fucking times. And then it says the parties had a screen share meeting last night. During that meeting, now this is where, when you're in this position, you can be snarky as shit because you're coming into court, like it's like a 2-on-1 in hockey. You got the puck and you're pushing on a defenseman. So we'll keep the Olympic hockey relevant here. Plaintiff expressed surprise defendant hadn't filed the motion as agreed. Defendant again said he was not worried, apparently because he believed the status letter had somehow vacated the court's order to time. And that's the thing. Until the court tells you it's okay, it's not okay. That's the thing. If a court, for example, a no contact order, I could file a motion, have a no contact order lifted until the court lifts it in writing. Or I get the judge saying it is lifted. Like I can visually, like I talk to the judge where I have it in an email saying the judge will grant your motion. We'll get an entry out the next day. It hasn't been granted. So just you saying, judge, we need more time, that's not automatically granted. That's kind of Russell Greery where you're like, well, I filed the motion. I thought it was good enough. No, that's not. Especially in this situation, once again, we're in the motion to compel territory. It's like, no, that's not good. That's not good. This is before the meeting. Defendant did not begin or make any of the production the night of the 17th, and no further production has been made. Although it is now past Thursday close of business. And this is the thing. When you start making deadlines for yourself, you can hang yourself with your own words. So instead of the production on Tuesday night, received an email stating, I was quite confident I'd be pushing something out tonight, but I'm having a lot of technical trouble. These are some pretty esoteric forms of data. Still sticking to supplementation no later than Thursday. Okay, but still didn't happen. So they point out the court issued 2 orders. And this is where they're pointing out, like, Judge, look, we've got all this here. And it said, first it ordered all communications by the 28th, warning that sanctions would follow for noncompliance. And they cite the January 14th order. Then after a lengthy hearing, it ordered all discovery, including discovery defendant was inexplicably waiting for the hearing to start producing, to be produced by February 16th. I mean, that's the thing. Did it happen or did it not happen? And they point out, and they, whether or not it was blown off or whatever it is, when you haven't complied, they can say you blew it off. You've allowed the other side to frame the issue. And it's hard for the court to look at it and say, well, I don't know what's going on here. He did not ask permission, which court rules would have required him to do at least 2 business days prior to the deadline. Yeah. Um, once again, your local rules will make or break you. Your local rule, like the rules can break a case so fast. Not necessarily criminally, because in criminal cases, you're like, yeah, in the interest of justice. But for civil cases, nobody, like the courts don't give a shit. Follow the rules. Follow the fucking rules. Um, and they say, and they point out, they word it out a little more eloquently here. But yes, instead of that, don't ask for forgiveness when you can ask for permission, the whole idea. He didn't even ask for forgiveness, despite the court promising he would. He violated the extension he granted himself, which, once again, they're going to hang you on your own words. And it says the law is clear on this, and it's true. The court order remains in force till it's vacated or stayed, and a party disregards it at its own peril. Yeah, until the court tells you don't do it. Yeah. And yes, okay, follow the rules, yes, but when you are a lolcow pro se plaintiff, it's always different. But when you have attorneys follow the rules, man. You got to follow the rules. And notice there is apparently they claim they provided tutorials on how to handle Twitter data. You can get the data off Twitter. It's not the easiest thing in the world, but it's not hard. Now they also point out there's ambiguity whether the court meant the 16th or the 17th, but they point out, but because the court required a letter to the status on the 17th, the court did not alter the defendant's request. So they're pointing out like the ambiguity doesn't matter because you missed either deadline. And they point out a scheduling order cannot be cavalierly disregarded by counsel without peril. Remember, this is the part where they're kind of like on the attack. So you know what? You press the attack. And if I was, I guarantee you, if this was Ron on the other side of the issue, Ron would be pressing the same attack probably at this point. You press the attack you have. You press the attack you have. Nor is there any question the disregard here is cavalier. Well, see, they're saying that, but who knows? Like, they could, but the thing is, when you're in this situation, you can make that claim. And the court's not going to say you're out of line, counsel, because, hey, it kind of looks like it. The defendant said he was not worried about a deadline the court set, and even after it was brought to his attention, he failed to make a motion to adjust the deadline. Notice they're pointing out he doubled down on his lack of worry. And once again, you get to be a big fucking asshole here because you're the guy who hasn't fucked up. The status letter was perhaps awesome in the sense it should inspire awe, but not in a way that is complimentary for a defendant. Once again, you get to be snarky at this point. When you are on the, when the other side's about to get shelled, you can sit there and just be like, you could drink your drink or you could sit there and point and laugh. Rule 37 allows a court to address this violation of court orders. And it says willfulness of the kind defendant admits with his lack of worry is a key factor in determining the appropriate sanction for violating an order. And it says here the threat of fees alone, which the court reminded the defendant at every stage, remain pending. Yes, the motions for monetary sanctions are pending. And they're saying that hasn't created sufficient worry to get things out here. And they say even if there is subsequent compliance, the attitude to the court's orders calls for remedy. And defendant has publicly stated he is waiting until his back is against the wall before anything is needed to be given because that's how he operates. And they go back and chat. This is why, once again.
Nigga, is you taking notes on a criminal fucking conspiracy? What the fuck is you thinking, man?
So some of you might ask, well, what would your advice be in these situations? Well, you don't talk about your case. So you don't talk about your case. Or you say, we will follow all rules and follow all orders and comply with where we're supposed to comply. But even then, I wouldn't recommend you say that. Just say, I ain't fucking talking about it. I ain't fucking talking about it. Kind of like Dave Chappelle said, shut the fuck up. That's because now look what you did. Look what you did, JT. So They say even if some production occurs, sanctions are proper if you're late. And that's true. And they say, given the public admissions, he wouldn't do anything until his back was against the wall. Sanctions are indisputably proper. It's again, everything you say can and will be used against you, especially in a civil case. And they say, here's the point. They say jurisdictional defenses are waivable. You can waive jurisdiction. The defendant has repeatedly expressed a desire to move quickly on to the merits. The court should enter an order precluding the defendant from raising personal jurisdiction as a defense. So what does that mean? The court could say, you know what? This whole issue about Alyssa's case being dismissed for a lack of personal jurisdiction, you have defaulted on that issue. I have deemed it waived. Your misconduct. Since you didn't help make that happen, Captain, poof. I consider it a non-issue. I rule. My ruling, that would be an upheld ruling. I hereby declare personal jurisdiction is not a problem. So guess what that does to Alyssa's lawsuit? That dismissal for personal jurisdiction, her case was on life support. And you know what that is? The defense is saying, not defense. Alyssa's saying, Judge, instead of money, we just want you to give the case, resuscitate the case. So just charging the paddles and, Battlefield style going clear. That's what they're asking for. Yeah, I don't talk about active cases. I don't talk about cases. And there's that case where I had to deal with that bullshit. People tried to ask, what's going on with that? I'm like, I can't fucking talk about it. I don't talk about my fucking cases. Now, obviously, I'm not doing anything fucking important or impressive, but I don't care. I'm not talking about a case where I'm representing Joe Shit the Ragman. I don't care who it is. I'm not going to fucking talk about him. I won't. I don't. But that's not saying you can't, but there's reasons why you don't fucking do all that. And if you are ever sued, as a party, this is why you don't talk about this shit. Because you just riffing and running your mouth. Well, now you just give it, you're putting bullets in the fucking magazine for them. You're taking and loading that fucking magazine with ammunition. You go, here you go. And now they shoot at you with it. It's don't do that. Don't do that. And they're allowed to do this. It's a valid point at this point for them to do this. At this point. And then from here, the next day, the court ordered a response to the motion for sanctions. And here's where things happened. And here, notice where things are starting to pick up here. Defendant's also expected to explain his failure to seek an extension or comply with the deadlines, which he requested, meaning, and the court cites this, how much time do you think you need? A week. So the court, this is once again where you get hung on your own words. The court's even agreeing, yeah. Was it toe sniffer, wasn't it? Well, yeah, but I mean, you guys have brought that up. It's out there. It's all out there, all that information. I haven't talked about anything privately he said, and anything he said off, anything I've disclosed is on the record that you can find. And if I was currently representing him, I definitely wouldn't talk about it. What's going on in Joe Shit the Ragman's case? Oh, funny. You're a funny guy, Sully. So, can you tell us about the toe sucker? I can only tell you what's out there online. Because that's, once again, I think that's only fair to those people. Did he describe to me the smell of the feet? I did not ask. So, Ron is now a law lawyer. I wouldn't say that, but I mean, I think that these are easy things you could avoid to deal with. These are easy enough things to avoid. Oh yeah, I think totally that there's somebody funding this because Alyssa doesn't have the kind of money this case would take so far. But if they win monetary sanctions, it doesn't fucking matter at that point. So, whew. Did he describe his foot rating system? We didn't talk about any of that. But notice, this is the court's even saying, yeah, hey, Ron, listen, you better fucking tell me why you asked for all this time and you didn't meet it. So, there was a sealed letter, a sealed document got filed. A document was filed under seal. A bunch of stuff got redacted. So we haven't seen it. We don't know what it is. But I mean, if you guys want to know what this is here, because I know some people are like, what was that all about? Well, we'll show this here. So this is something that was filed, a couple days later. They say they right to provide an update, particularly in light of the court's order. This is there's because now they're like the court. You notice that court order is not good. If you're the defendant, that's not a good thing. If you're the plaintiff, you press the attack even harder now. Was there an in-person lineup of feet? Fuck you guys. They provide an update, particularly in light of the minute order. They say, as set out below, defendant produced last night. And notice, this is the, all this is happening the day before the minute order came out. But they're going to bring up, like, here's what we got. Here's what we got. He produced a large volume of documents. It was sent as 8,800 pages of an undifferentiated PDF and no formal supplement to the responses. This came just over an hour after plaintiff filed the sanctions motion. And it says, as the Second Circuit's clear, partial compliance does not moot the motion for sanctions because, yeah, you didn't do it. You didn't get it done. They're pointing out that we did get it. And this is something here that was sent as an email, and I'm assuming this is word for word, because if you lied about this would actually be bad. Ron apparently said you have programmatically abused the judicial system by filing this meritless, I'm assuming, motions and exploited every effort of good faith and cooperation in litigation. You can correct the record or I can do it for you. Now, does that mean that, like, Ron was kind of treating this like he's dealt with more, like there's been a little more collegiality between the parties? Sure. And this gives us a little context. It wasn't just Ron was going like, oh, well, fuck it, I'm going to go take a nap and eat a sandwich. No, it sounds like Ron was probably operating on where he's dealt with other attorneys who have been probably more collegial and cordial to each other. But this is a situation where, once again, Alyssa has attorneys who are very much ideologically in line with her and are fellow travelers with her and view things similarly. So guess what? Instead of it being kind of like, oh yeah, hey, we're going to work back and forth, it's real fucking hard-nosed right now. And it sounds like Ron was kind of like, I'm going to be collegial, and Alyssa's attorneys are playing real fucking hard-nosed. Yeah, that's a little rough. If you're used to playing beer league hockey and the other side is used to doing, like, not afraid to throw elbows and, fucking ride you to the boards, or, like you're used to playing like flag football and the other side is, a former D1 athlete, and it's going to jam you up right on the line. Yeah, it's a little bit like it's going to cause problems. Yeah, and I think that's Ron's problem is he put some faith that, this is one thing I will fault Ron for. Ron's not politically ignorant. Like Ron is very conservative. I'm sure Ron may not agree with me that communists deserve to be thrown out of helicopters. But the idea that Ron, dealing with people who are clearly on the side of Alyssa, who are hard on the left, I wouldn't fucking trust him as far as I could throw him in a legal context. You have to be hard-nosed with these people. You know what? They're the left. They're the left. The left wing only understands the boot heel. That's all they understand. That's how they understand. Dean Rusk Or Dean Acheson was right in 13 days. The Soviet understands only force. The communists only understand force. And yeah, that's the thing, David. I think, David, I know as an attorney, um, he says Ron comes from a place like I do, if you don't get along, it pisses the judges off. Sure. Sure. Can be. But knowing the court is part of the practice. Yeah. Knowing the court, and yeah, that's knowing your judge. Remember, guys, if there's a bunch of judges in the courthouse, they all could have different, you need to know what that judge, how they handle shit. And it sounds like this judge is more formal and more business minded. I don't know if this judge is a raving communist, but these guys basically kind of set it up, and did they take advantage of Ron's collegiality? Sure. But at the end of the day, like, their job is to represent their client, not be friends. Not be friends. And I think that provides us a little bit of context as to what's going on here. Because I know some of you guys are just sitting here taking a crap on Ron, but it's like, Ron, I think, was operating that these guys would be collegial about things and we could operate in a traditional sense, which is a little weird because Ron's been to the Supreme Court. Like, this is lawfare. And that's where I'm a little confused that Ron didn't, Ron got so caught off guard that, like, he jumped into the trenches and thought like, oh, we're gonna, do the Christmas truce again. It's like, no, you're gonna get shot in the fucking face. So, they point out, though, to be clear, we have not agreed to an extension. More importantly, we have repeatedly tried to remind counsel they have no authority to agree to an extension of a court set deadline. The court set a deadline, even if we agreed, we can't agree to it anyway. And also, apparently, plaintiff was clear they would file the motions in absence of an extension request. So Ron didn't properly do that, so they filed the sanction motions. So they point out every indication appears in production, blah. Defendant has not produced the Give Send Go data with emails, which I don't know what you have access to under Give Send Go. The documents produced are inconsistent with the text searchability. OCR appears to have been removed for some pages, but not others. That removal is indications that the documents with text searchability were flattened to eliminate OCR, or perhaps by a redaction process, which, I don't know. The electronic discovery of this scale is a pain in the ass, so we'll see. The defendant mass designated the entire document confidential, which you can't do that. That's actually not good. Even the messages, this even includes the hypnotic messages that were produced as video and no designation before. There are redactions, but no privilege or redaction log, and this is something you have to do. So if you're, for example, in discovery, if you're going to block something out, when we've seen like federal stuff like classified documents, what they have to do is like, like, if you guys have ever watched, like, if you guys have, like, we've looked through federal documents before, it's classified pursuant to 15 USC 968 C2A1. For whatever reason, we don't have to show that to you. It's classified. That is, that's what you have to do. That's part of a privilege log. And this is actually probably a great example. This is an example of what, like, and you'd have to have a separate document showing here's what all that stuff means. We can't give you that document. I can't give you this document. Blah, 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 blah. And you have to explain why. And like, this is attorney-client privilege. This is work product. Yada, 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 yada. Yeah. And I don't think Ron realizes these people are coming for JT's scalp. Yes. They are trying to break him to silence dissent. This is an attack on free speech. This is a bunch of Bolsheviks doing Bolshevik shit. Yes, and I don't know if he really appreciated it, but you have to do things like that. If you don't do it, it's not helpful. A privilege log, and this is per local rules. Once again, local civil rules. Privilege logs must be provided at the time of the response to discovery and disclosure. They point out that there's still documents don't exist or haven't been produced. Not a single email has been produced despite a promise to the court by counsel. The court said, Mr. Coleman, are you producing those chats and those communications and those emails? And Ron says, we will produce those chats, communications, and those emails. You know, this is where you got to be very specific and say, Judge, I don't know if there are emails. If there are, I will provide them. I will provide them. You know, over 100 pages of relevant conversations, the specific chat GPT conversations about jurisdiction. Defendant showed on stream. So, yes, chat, you're reading that right. Fucking JT fucking started riffing with fucking Grok about jurisdiction. It's like, dude, you're not fucking, like, why would you do that? Why? Especially after the lawsuit's going. J-Rox, I don't think it's an epic great case on free speech. If Alyssa wins here, they're going to go after everybody who gives her shit or steps to her. So, yes, this is it's not this case being a landmark thing, but this would be used to then allow these, you know, the Bolsheviks to go harass everybody else. That's why. But this is, guys, don't ever fucking do this. This right here is fucking ridiculous. Don't ever fucking do that. Don't ever fucking do that. J-Rock says, are they, Sean? Are you next? I don't know. They fucking come after me. They can see how many N-word towers we build in Discord. Great. Yeah, they're trying to make the stochastic terrorism a thing. They want to fuck with people. Yes. So, just, you know, notice there's all kinds of stuff here, though. More redactions, more redactions. You know, and this is where, once again, every time you talk about things, the parties will use it against you. They say the mass undifferentiated designation is on its own a strong indication the production was rushed out the door. Given defendant counsel's public statements about this case, he says, I try not to bog down on discovery with a lot of over designation. This stuff is confidential. As of January 21st, 2026, as the motion to compels are brewing, I'm sure Ron didn't mean that in a way that could be used against him or be used in bad faith or used non-charitably, but he fucking sets himself up for it. You set yourself up for it when you fucking do this. Like, this is why you don't do that. You have to be, like, the people you are fucking with will use every single word you can use to, and they will fuck you to death with each word you use. You need to be very careful about that. Mindful of what you say. And I will say my one of the prosecutors one of my electeds, really good guy. Like I said, I enjoyed working for him. He pointed out, he's like, you know, especially since I've been elected, you know, he says, obviously that can affect whether or not I keep my office. But he says, more importantly, you should always be when you're making comments, be very thoughtful about what you're saying in these situations, especially if you know somebody's watching you. And it's like, yes, when you're the state and when you file a motion, you need to be very explicit and clear what you're saying. When you are the opposing party in a lawsuit and the lawsuit is kicked off, if you have to talk, you need to be very explicit and very careful and measured in what you say. This is, yeah. So, yes, this is true, David, here, yes. Building disastrous case law by strategically suing retards is the most undiscussed flaw of the common law system. Yes, but that's what they're doing. They're going after the low-hanging fruit because then they can build up case law on people. And if they can't build up case law, they'll just chill and scare people. So this goes on and on and on. They say these are not all the issues, but they have a strong indicator. They rushed out what they could out the door without care. And they just point out, like, we're just we're getting fucked around here. They say, they point out, They say first, blank, 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 blank. They're saying that this is concerning given his attorney's public admission he never reviewed the first DM production, saying, I mean, I think I watched that 2 hours. Yeah, and frankly, you don't want me to pay for that, okay? Once again, why would you fucking talk like this is why you don't talk about your case online. This is why you don't talk about it online. So, has Ron recalibrated his scorched earth yet? I don't know. I don't know. I don't know. But yeah, like I said, Ron was expecting this to be, collegial, and he got a knife fight instead. Doesn't mean he can't fight back. I know Ron can fight, but it's like they got the upper hand right now, and you have to fight back. So, this just goes on here. They sought certain communications based on public disclosures of parts of advice and communications. Now, think about this. If they had complied with all this other shit, and then these guys are crying about the attorney-client stuff, Ron might be able to say, Judge, fuck these people. And the judge might have already said, yeah, you're not getting that. But because nothing else has been given, the judge is like, yeah, you're getting everything that they're asking for right now. But notice a bunch of this is redacted, so we don't know what the hell this is. Don't know any of this yet. Has not been unsealed. And once again, it's yeah, they point out here though, once again, JT himself literally used the verbatim standard the Second Circuit set for sanctions when describing why he not completed discovery. I was waiting until my back's against the wall before, that's how I operate. Once again, why would you fucking say that? And he said it as of the 14th. I don't think JT is a bad guy. But you can't fucking talk about this shit. You can't talk about it. I mean, holy fuck. Holy fuck. Sellers says it's going to be awkward. I don't think so. I think Ron would agree. Yeah, he's like, he took these people to be more collegial than what they were. And yeah, when you're dealing with people who are going to sit there and fucking use everything you say against you and like, they're going to get all perstickety and get all melanated about every word you use. Okay, fine. Yeah, but like you're putting it out there. They're going to like, you can't be like Pikachu face. They're going to use it. I just think that's a little bit of probably naivete. Like you're dealing with revolutionary communists. Like they don't play by the rules. So they want sanctions appropriate. They're still saying, Judge, we're giving you an update, but we still want sanctions. So that all happened. There was a motion to seal. We're not going to get into that here. We're not worried about the motion to seal, blah, 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 blah. There was a response by Ron Coleman to all of this, and we'll get to this. It's actually, I think it explains, he points out a lot of things. I have too many tabs open. I'm in Kirsha mode. I can't have all these open. God damn, too many tabs. Too many tabs. Tabby, tab, 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 tab. I will say though, for Ron's stuff, these like cream colored letters are very soothing to the eyes instead of just staring at the white. So, but this is Ron's response to everything. And remember, it's all been a one-sided thing. So I know some of you guys are bagging on him the whole time, but remember, we haven't had the other side hasn't responded yet. So here they are. Taboo only works with Kirsha, not so much with you, Sean. Oh, well, that's good. Yeah. Did I just say tabby, tab, 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 tab? Yes! I have a lot of tabs. So Judge Ashkenazi. Yes, that is the actual judge's name. Yeah, Judge Ashkenazi. Parenthesis. He says, I am counsel for defendant and write in response to this motion for sanctions. He says, I also address a supplemental letter filed and also at the court's direction. I'm doing everything you're telling me to do here. The extension issue. I begin because it is a subject of a court-specific inquiry And because I owe the court a candid explanation. Yeah, and you know what? You might say, why would you say all that? I would write it like that too. Your Honor, I provide the answers. Here you go. Short answers that I made an error in judgment. Okay, I fucked up. I believed incorrectly that the joint status letter filed at 55 effectively communicated to the court additional time was needed and the matter would be addressed at the next conference. Now, I understand Alyssa's attorney is going to say, we told you no, but Ron could say, fuck, he could be like, fuck all that. I think this was. Now, it turns out he wasn't right, but the joint letter explicitly stated the defendant is contemporaneously making a motion to extend time to comply. Corresponding dates. He says, I take responsibility for the fact that separate motion contemplating language was not filed. Okay. Taking responsibility. The plaintiff makes motion in my email statements that I was not worried about the deadline. And here's the problem. If you hadn't said that like that, or you hadn't been off the cuff, and once again, Ron was dealing with these people kind of in a laid back way, being kind of collegial. If he hadn't said all this shit, he wouldn't have to write all this. And it'd be less stuff for him to have to go, well, what had happened was. But if you have to say what had happened was 1,500 times, that looks bad. That doesn't mean it's bad, but that's not good. If you can limit this, you should. That's why you need to be very careful when you communicate, especially in the situations you're in. Once again, like I said, I think Ron was trying to be collegial, and these people aren't. They're playing hard nose. He says, in the context, those emails reflect my mistaken belief the status letter approach would suffice. Now I contempt for the court's authority. He says, indeed, at 2:09, before the deadline expired, I emailed opposing counsel to confirm the scope of supplemental production and to schedule the virtual meet and confer the court had directed. The production effort was ongoing and communicated to plaintiff's counsel throughout. Yeah, but it's like, what the fuck was taking so long at the end of the day? Are Mercante's lawyers from New York City? Yes. Well, Ron's in the area too. Ron's in the tri-state area. He's like Ron and Joe Neerman go to the same shul. They go to the same temple, I think, or are in the same social circle, in the same social community, in the Orthodox community. So the production effort's ongoing. He says, plaintiff's email confirmed the plaintiff understood supplemental production was forthcoming no later than Thursday the 19th. Defendant proceeded in reliance on that shared understanding of the timeline. Well, once again, this is where I think Ron was probably and this is where it's kind of funny. This is kind of a lot of places attorneys can kind of be collegial, but once again, I think he was operating with people who weren't. So they're not Briss brothers. No, Jesus. And at 6 p.m. on the 17th, I acknowledge the technical difficulties that arisen, reaffirmed the commitment to production. This is actually kind of curious, and I'm wondering if the court's going to say, well, what is the technical difficulty? What was it? And this is where, if you were having a problem, what is the problem? Did my did we get hacked? Did the internet go down in my area? Did my house catch fire? What happened that I couldn't do it? I think that's probably what you need to explain. And if you need to say, sorry, I'm a fucking boomer and I don't know how to operate shit, maybe that's an answer, but you need to I think you need to explain what's going on here. I think you need to explain what's going on here yet. So, he says, that is not the conduct of a party proceeding in bad faith. It's the conduct of counts. And here's the thing. This is where I think it's more of Ron acknowledging that he thought this to be more collegial than what it was. It's a conduct of counsel who believes the parties were proceeding cooperatively and a short supplemental period was understood. This is where you kind of get into that issue of Ron saying, well, I thought we were actually going to try to work together on this. Well, surprise. No. He said the plaintiff did not need to file this motion. I mean, I don't know about that. They have the right to file it. Plaintiff's counsel is aware the time of the filing production was actively underway. Yeah, but still the deadline was not met, so they could do it. The motion was a litigation choice, not a necessity. Well, And Chad, I apologize. I had only read up to this part. I hadn't read the rest of it. Been a little busy. Um, but I mean, yeah, like, okay. So, like, once again, I think this is Ron saying, like, I thought we were going to be collegial about this and be attorneys working to resolve the issue. And instead, he's like, fuck, these communists are acting like communists. Like, wow, they're trying to burn my house down. It's like, yes. He says the email record confirms the parties were communicating about the production in real time. Plaintiff was informed of the technical difficulties and that a specific deadline had been discussed and acknowledged, but you didn't get it from the court is the issue here. In my experience, when parties are in communication about a short delay of a day or two in meeting a deadline, the professional expectation and the standard that serves the interest of justice and judicial economy is to work the matter out between counsel rather than rush the court with a sanctions motion. That's true. The court would rather you guys work your shit out. But if the court sets a deadline and it's not met, they don't have to. It would be preferred, but they don't have to. So, yeah, I mean, that's the thing here. That's the thing here. So, it's also worth placing in this context. The defendant has now produced nearly 10,000 pages of material. This represents a massive volume of discovery. For single individual persons, yes, that's actually a lot. But, you know, real federal litigation could be like millions of documents. One that would be substantial in any litigation, yet this is supposedly jurisdictional discovery only, the purpose of which is narrow and limited. He says, whatever deficiencies remain in production, the sheer volume of what has been produced reflects genuine effort, not contempt. The characterization of this as willful noncompliance does not withstand scrutiny. The problem is you made all your fucking comments and your client made all your fucking comments, and now they're using all that against you. Once again, you thought you were dealing with people who were going to be reasonable. You dealt with very unreasonable people. So yeah, this is kind of like a shock Pikachu moment. The defendant is also proceeding their standing cooperative arrangement was in place. Significant concessions have been made on scope and format. Defendant understood the parties were working collaboratively. I hate, you know who collaborate? You collaborate with the Nazis to reveal the Jews hiding in someone's attic. I hate that word, collaborate. People collaborate with the Nazis. I always hate it. I always hate it. But I understand it's one of those words like synergy or whatever. It's, it is what it is there. It's just a word I don't like. I don't like it. I don't like it. At the end of the day, I really don't like that word. So, it's hold on here. Where am I looking for? We'll bring up, some of you guys are saying, well, what about the offers to dismiss claims? Somebody just messaged me on Discord. I'm going to get to that in a second here. So, yeah, the TLDR to this, guys, is don't fuck around with deadlines. Sure, it is. And he says, the defendant understood the parties were working collaboratively through discovery challenges, including the collection of data from like Give and Go, a massive number of DMs, and LLM transcripts. The motion admits this cooperative backdrop entirely. Well, yeah, but you didn't get it done in time. And it says, turning to the legal standard, the sanctions request and order precluding defendant from using jurisdiction as a defense are among the most severe available. Yeah, but when you're in discovery, that's a pretty effective one, which is equivalent to a default on jurisdictional questions. Like I said, it's a default on the issue. And it says such sanctions are reserved for cases involving willfulness, bad faith, or any fault of a high degree. Once again, if you know what helps to show that you're not doing that? Just speaking kind of off the cuff and cavalierly about the case where they're taking notes on you. Don't give them ammunition. There must be a finding of willfulness or bad faith. Well, those comments can be used as willfulness or bad faith. This is before imposing the sanctions, courts also consider whether lesser sanctions would be effective. And it says the delay resulted from a combination of technical challenges of compiling data from platforms, a volume of data that was not anticipated, and a procedural misstep regarding the extension. These circumstances do not rise to the level of bad faith and will not justify striking of a jurisdictional defense. The own February 20th email confirming the ongoing dialogue further undermines any claim this was deliberate obstruction. And Ron gets onto the case law here. He says they're now relying on the Klipsch group. And he says, for the proposition sanctions are proper even after belated compliance. He says, Klipsch, however, involved years of discovery abuse in case terminating sanctions affirmed only after the district court found repeated deliberate concealment. Sure. And it says, it does not stand for the proposition that every missed deadline, however regrettable, in the context of an ongoing production situation where a defendant has nothing to hide, well, you be very fucking, like... You don't know that. You don't know that. You don't know that. That's a very dangerous thing. Like, I would never say that about my clients. I don't know. I don't know. Like, what is your client hiding? I presume nothing, but House is right, though. Like, Dr. House is right. Everybody fucking lies. Everybody's got something they're hiding. Like, I can't promise you that's the case, but I presume there's something out there. Like, I'm always just waiting, like, so I'm not surprised. Like, I'm not surprised when my clients lie to me. Especially in, like, civil cases, divorces, or child custody stuff. Like, oh, your new boyfriend has, like, a fucking armed robbery conviction out of Alabama. Well, I didn't tell you. You didn't tell me that. Like, yeah, I'm assuming something's out there. Something's out there. I never make that argument. Oof. The plaintiff also cites the statements on a YouTube live stream. And it says, whatever rhetorical use plaintiff makes of those statements, they are words of a litigant on a public live stream, not representations of counsel to the court. Okay, this is like I said, I respect Ron. He's a good attorney. This is boomer cope. This is boomer cope. They bear no relevance to whether they acted in bad faith in the discovery process. They're your fucking statements. They can be 100% used. Everything you say can and will be used against you. This is here. Indeed, it would be useful. And this is where, once again, I saw this clipped out on the farms. This part here. Indeed, it would be useful if plaintiff would put aside its practice of tattling on the defendant and his lawyer by placing fundamentally irrelevant materials and comments in the litigation record. Once again, I think Ron thought he was dealing with collegial people. You know, he expected this to be polite, and instead they stabbed him. I mean, I don't know what to say there. So, but it's one thing, and you might be able to argue, okay, well, that's a little bit melanated to use my own statements as an attorney. But your client's statements, to quote the great Ethan Ralph, that's all fair game. That's fair game. That is 100% fair game. And if I was in a lawsuit suing a party, I was hired to be plaintiff's counsel, or I'm defendant's counsel, and the opposing party themselves, the plaintiff or the defendant, is out there making fucking public statements, you bet your ass I'm fucking firing up a downloader and fucking downloading that shit and fucking seeing if I can use it. And if there's something in there, I am fucking using it. You goddamn best believe I'd be doing that. Holy shit. The idea that you wouldn't, I think, is, especially for the party, I think that's like, YouTube doesn't count. It's like, it's a fucking public statement. Yes, it does. Once again, I think that's Ron being a little boomery. Like, it's 100% fucking valid. 100% valid. So, yeah. God, I hate this when people are messing, like, fucking Discord beeps all the time and then nothing's on there. So, and then real quick, we have, I'm going to just get these because they're noticed here. EDW Raptor for 20 subs. Thank you. God, guys, I said it'd be like an hour and we're like 2.5 hours in. Sorry. This is serious shit. We're gonna get to it. I'll let you guys get to the casino here in a second. Everybody's left. But ultimately, yeah, this is it's in a transparent and unprofessional attempt. Is it really unprofessional? I would argue it's not. Sorry, but EW, we're gonna get a woo here in for you for that. Thank you, man. It's good to see you tonight. I hadn't seen you around, but good to see you. Thank you for being here, man. Thank you for being here with your 20 subs. It's kind of like that Johnny Cash song about the the gunfighter. The old good fighter stood on the porch and stared into the sun, and thinking of all the things he had done. And he walks out into the street and he's out there in the middle of the street and he gets ready to turn and draw in a gunfight, he gets hit by a bus. It's like war change, war never changes, but how you fight the war changes. Like, it's like being leading a cavalry charge into a machine gun nest. It's like war changes. Is this unprofessional? I would say no, not at all. Not at all. So Johan for 5 subs. Thank you, Johan. Thank you. And is Clyde right here? Hold on. Clyde, are you right here, Bubba? Oh, he is. He's hiding from Louie. Clyde, come here, buddy. Come here. We'll take a Clyde break real quick. Come here, Clyde. Oh, he's like asleep. Oh, he just like rolled over, looked at me. He's like, fat man, I am too tired. Oh, that's okay, Clyde Bear. You're okay, Bubba. I'll let you stay sleeping. Yes, war never changes. Interlinked. Hi, Shredder. So getting hit by a bus changes a man. Yes, thank you. Easy litter box cleanup. Oh, he says a more proportional response would be, and obviously when you're on the other side of this, you're saying, Judge, just give us a stern talking to. We don't, this is not anything special. This is very common. Set a firm deadline, requiring a privilege log, reserving the question of fees, as the court has already indicated. Yes, defendant would comply with such an order promptly and fully. Problem is, you've already said, I will get it right away. That's the issue here. That is the one part you do have a problem with when you're telling the judge I can take care of it. You've already told the judge you could take care of it. So he has to regret the procedural failures, the production efforts genuine, the volume substantial, the delay short. And his Ron says, please don't kill us, Judge. And to be fair, that's what you argue. Please don't kill us, Judge. So, and this is where, even though all that has happened, the court made a ruling yesterday. Court made an order. In evaluating sanctions, the court must consider things including willfulness, the efficacy of lesser sanctions, the duration of the period of noncompliance, and whether the noncompliant party had been warned. Okay. And they cite a Second Circuit case. You're like, all right. Here both parties acknowledge the discovery was ongoing and only several days late. Indeed, plaintiff filed a motion for sanctions just 2 days after the deadline for production. In light of the brief duration of the delay and the reasons cited by counsel for the defendant for the delay, the court concludes sanctions are not warranted. So yes, here's the point of this, chat. That doesn't mean miss deadlines and you can get away with it. Because here's the problem. When you are in court from now on, that scale is always working. And there may come a time where you need that judge to do something in your favor. And every time you want that scale to tilt in your favor. When you mess up, that hurts you down the road. So, but ultimately, they didn't get sanctioned. So nothing's happened yet. And I think the court believed Ron Coleman. I do. And I think Ron Coleman's explanation is credible. But this is a lot of risk and shit to go through to get to this point. She could have easily said, you know what? Alyssa's lawsuit breathes life again. The judge could have said, you owe Alyssa and her attorneys $25,000 or whatever it's going to be. You got to stay on top of this shit. And I think Ron is understanding now that this game is different. This is a different game than what he normally does. These people are not playing in good faith. And I think he understands that, and he's going to handle it differently going forward. And that's what he needs to do. But as I showed in the thing, was JT basically bobbling a hand grenade? Yeah. And he dropped the pin and the spoon went flying. Thankfully, it was a dud. But that grenade easily could have just boom and took him out. It could have. It could have. But it didn't. I mean, honestly, if you guys had seen when I posted on the farms, like, I posted my thoughts. I thought the court was going to fucking sanction him. This court, like you would like to think that it wouldn't happen, but relying on the benevolence of a judge is a very risky thing. I mean, like if something happens and you fuck up and you're dealing with it, yeah, that's all you got. But whoa, you don't ever want to be in that position. And I don't think going forward they will. But it's just an issue. It's just like it's a problem. It's never where you want to be. And then this came up around the same time as everything this week and last week. JT brought this thing up here. He says Alyssa's lawyers agreed or offered to drop the entire defamation claim against me. He says it was conditioned on the catch that I'd have to agree to give up my New York jurisdiction claims and give up my strongest procedural defense so they could keep the case exactly where they want it. So remember, this is weird, and I thought this was very weird. Number one, if they really made this argument, I would have held on to this for a little while. But this is assuming, and I don't think Alyssa or her attorneys or anybody has done anything to say it's not true. They are willing to give up the defamation case for the other stuff, which is weird. Either they must think the other claims they have against JT for like tortious interference, stochastic terrorism, yada, 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 yada. Those are more legit than the defamation case, which I think is fucking bonkers. I think the case is complete dog shit. Of the things like they might have a chance on, the strongest one would have been the defamation. I still think they lose at the end of the day. And I still think no matter all this discovery, I think as the discovery ends and we see when JT has to reveal what the discovery he has, Alyssa's still going to lose on personal jurisdiction. But let's say she survives personal jurisdiction. I still think she loses on the merits regardless. So that's why I think all this stuff was just like, it's just ridiculous. Like, they were probably going to win anyway. And it's like, what the fuck happened? And it's just like, you got to be on top of this. And if you think you're dealing with a bunch of fucking scorpions, like, realize if you're dealing with scorpions or not. And I think Ron has understood he's dealing with scorpions. But anyways, yeah, if they weren't just being nice, it was a trade. If I conceded jurisdiction, they dismissed defamation with prejudice. That is a show they weren't confident about surviving jurisdiction. I agree. But also I think their whole case is dog shit. So, and yes, he said if their defamation claim had real strength, they wouldn't have offered to drop it. He says, you don't abandon your biggest claim forever unless you know it's vulnerable. And this has been conceded into a procedural chess match that's burning time and money instead of proving anything on the merits. Yeah, and you got real fucking lucky you weren't just stroked by the judge for 15 or 20 G's. You are real fucking lucky, JT. Really fucking lucky. Because easily that could have happened. So we'll see what happens. We'll see what happens there. That's kind of the JT. We are caught up on JT. The next thing we need to get caught up is on Destiny. Maybe that'll be next Friday. I got to figure that out. I got to get caught. Holy shit, there's so much Destiny stuff, though. So let's catch up on the super chats here. Yeah, they went to stochastic terrorism stuff to get established. Yeah. They want to be able to use this lawsuit to go forward and attack other people. Yeah, this isn't the end. This is only the beginning. This is not an end. This is not an end. James Hurley says Razorfist is celebrating Smash JT's failure. I mean, it's not really a failure. He's still in the game and he's probably still going to win. So Razorfist is a sped. Well, yeah, I mean, if you're on the internet, you're probably a sped. If you're a creator, you're probably a sped in one form or another. Myself included. I mean, you have to be retarded to do this to an extent. Let's see here. AJ Red Sox, who's been a member for 4 months, says the dog wants attention. Well, the dog is missing its Laney's person is 2.0. I am not Laney's person. I try to be Laney's person, but based on the fact that she was a puppy mill dog and she was an Amish puppy mill dog, we think she has a healthy fear of men. So like any man, like if you have reached puberty, and you're like, 15, 16 years old, she starts freaking out. So I don't know if she'll ever get over that. She's been through a lot. So yeah, if 2.0 is not here, she panics all the time. Let's see. Rowan Cowart for $10. Thank you, Rowan. Says, you mentioned courthouses last night. Yeah, old courthouses are beautiful. I live where they filmed the scenes for My Cousin Vinny. Where they got pulled over is 30 seconds from my driveway. The exterior courthouse shots are at my county courthouse. Cool. You should put up a sign and be like, where My Cousin Vinny got filmed, and you could be like, take pictures for $10. And I bet people would pay if they're dumb enough out there. So thank you for the super chat. I appreciate it. Then Rowan's been a member for 18 months. Thank you for the support. It says, where they stole from is a few minutes away. Oh, cool. The store. Nice. Thank you. And then Nico says, I thought they just talked about Steel Toe's cock at DabbleCon. No, that's at Hackamania. And you're like, what's the difference? And I'm like, I really don't know. I don't really know. And like, not really sure. It doesn't really matter. I don't think so. JCXE saying Johnny Somali is looking at 2 to 4 years in prison. Yes. I mean, he's looking at being labeled a sex offender. Yes. Yeah, things aren't looking good for Johnny Somali. So it's looking bad for Johnny Somali out there. Trucker Rob for $2 says, Sean! Hi, man. How are you doing? Good to see you. Stabby says, if I could hire anybody as an attorney, I'd hire Ashley Mercante. Yes, and Ashley Mercante is the attorney who was involved in all the Fannie Willis stuff. She did all the, and remember, she blew up all the information about her and Nathan Wade. And remember what she said. I did it all through FOIA. Once I learned about something, I just started asking for documents, and they were given to me. And J-Rock says Discovery Games never worked out good. Just produce what you got. Yeah, and the problem is if you're having problems, like, get it fucking done. Get it done. BobTube says for $5 Australian dollary doodles, can't Ron give Judge Laura the secret handshake and resolve the case? Maybe, but he hasn't had the chance yet, it sounds like. That's another procedure that has to happen. So. Objective Gestalt for $5 says, you done goofed when the non-binary trans opposing counsel. I think he identifies as she, her. But anyways, so not non-binary, but definitely trans. Opposing counsel comes across as the more professional one. Yeah, and that's the thing, guys. If you are the guy who's done everything, it's like in The Departed when Alec Baldwin's Mark Wahlberg. He says, "I'm the guy that does my fucking job. He must be the other guy." If all you've done is like, Your Honor, I've just asked them for stuff and they haven't given it to me, you look like $1 million at that point. You look like $1 million. And now, did Ron provide explanations? Do I believe him? Yes, but Ron had to go do all that now. That's the thing. Like, it's if you didn't have to do that, it puts you in a stronger position. So, but yes, thank you for the $5. David Hinkin says, if you'd have filed a motion that just said I boomer my computer, he'd be in a way better spot. Judges get booty blasted when you try and agree away their orders. Yes, very true. Very true. Just say, Your Honor, I'm a boomer. I had problems here. But that's one of those deals of you got to know your judge. You got to know your audience. And J Rock says TLDR, don't miss deadlines. Well, that's always true. Yes, always true. True. Or to quote Cog, it's factually accurate. So, let's see here. Got any things else? No. You're saying maybe it's some of the wrong part of the country, but I didn't know Amish puppy mills were a thing. Oh yeah, fucking shitloads of Amish here in Ohio. But yeah, they puppy mill. The Amish do all kinds of sketchy financial shit. That's what they do. That's what they do. Um. Oh, it's yeah, it's they they do all kinds of shit. But yeah, no, the Amish they do puppy mill stuff out this way. So poor Laney, yeah. Well, Shino Boo Boo says Razorfist cheering for commies, not surprising. Um, no, but I mean, if you think somebody has fucked you over, you might cheer on their demise regardless, whether or not it was justified or not, or whether or not it really happened. So, make sure we miss anything here. Fun Gussie says it's funny when I was a kid and I thought the law was technical and just about what's in the law. And then lawyers are always like, just be friends with the judge. I mean, it's not just like, okay, that helps at times. And there are times where being the homer in the courtroom helps a lot. But yeah, I mean, it's like anything in life, having interpersonal relationships never hurts. Maybe it might not help, but it can't hurt. If I walk into a courthouse and I know the prosecutor and we've got a bit of a rapport and stuff, it can sometimes go a lot better for me if I'm like, "Hey, man, cut me a break on this," than if I've never been to that courthouse before. Sometimes that's tough. Now, there are some prosecutors who are like, "Yeah, show you some love. Thanks for coming out, homie. Hope to see you in the future." Sometimes it doesn't. Sometimes it doesn't. It's just the way life is. Way life is. But no, and I will say because I've heard people. There are people, a law tuber or two has said before repeatedly. They don't say it anymore, but they had said before, like, just you pound the law and you pound the facts. And it's like, that is not fucking it. There is so much more to it than that. There is so much more than that. There is so much more involved. There is so much interpersonal issues involved. There is, all kinds of things at play. So yes, having those relationships, knowing these people, knowing what their ticks are, knowing what the rules are and how these rules are enforced, and knowing all this background information and side information. Knowledge is power. Knowledge is power. It's not a thing here. It's not, it's true. It's true. So Little Mrs. Wait, we're live. I just go off of a live explaining this to a Suid and an Aussie. How political so many judges seem to be, I don't know who the hell would believe you can get away with just relying on the law. Look at juries ignoring the law. I mean, no, that's too, man. It's you know, politics and the law are very intertwined. I mean, because politics shapes law, and law also shapes politics. Like they very much go back and forth on each other. Like Andrew Breitbart said, with culture being downstream of politics. Um, yeah, but I mean, when it comes to law and politics, they're kind of like in a whirlpool where they keep affecting each other. So, yes, and politics is downstream from culture. Yeah. So, yeah. But anyways, they survive for now. I'm sure the judge is going to remember this though, and the judge is going to be like, okay, well, like she's not going to like, oh my God, you're a piece of shit. But she's like, okay, we've had one fucky wucky. You don't get a million of them, so be careful how many fucky wuckies you have in front of the court. That's really the moral of the story here, chat. So they survived to fight another day, and I think JT and Ron learned their lesson of who they're dealing with and need to be hard-nosed and protective of themselves. Like JT, really don't talk about your case anymore. I really not recommend that. But just remember, these people are looking to fuck you at every chance they get. They're looking to fuck you every chance they get. Don't let up on it. Don't let your guard down. Don't let your guard down. So, well, that said, chat, we are going to wrap up here. That is it. Everybody left. So, oh well. You guys are here. I appreciate you all being here. Tomorrow we are going to work on getting through Corey Richins and catch up on that. And yeah. So Joe says, I'm still here. Yes, a bunch of you are still here. Nico's like, GG. Good game, fat man. Oh. So with that said, chat, no model time. I mean, no, I am tired and I'm probably I gotta go spend some time with the doggos. Like, I need to sit down with them and kind of sit on the couch with them and, play with the toys with them a little bit. They're a little lonely. They're a little lonely. So want to take care of that. But Chad, I will give you some updates. We have while we were working on the Corey Richards trial and stuff, the Panzer III is done and it's based. And the other part of the Africa Corps kit, which is also done, and I did a little bit of modification too, is ready to go. The 88 millimeter, the Flak 37. It's done. It's ready for painting. So we're not just assembling anymore. But also I did something neat. It comes apart because I want to be able to store it in my carrying case. And how do I get it apart? We got little magnets in there. So boop. But anyways, it's fully articulated. It can, we could shoot down airplanes, but more importantly, we could just go, flat trajectory and take out a tank. So I'm not putting the gun shield on it because I think it looks like garbage. So, but anyways, that's kind of the update there, guys. So we'll work on this. Corey needs a model cam, yeah. Little Misses, have I already heard any songs by Celeb Token? No. So we'll work on those at another point here, chat. I don't know when, but we'll do that. So with that said, chat, I will talk to you guys later. And remember, till next time, just because you did it does not mean you're guilty. But don't fuck around with discovery deadlines. Never a good idea. Good night, chat. Take care. And I still hope Alyssa's lawsuit crashes and burns because I think it's absolute fucking horseshit. So good night, chat. Bye.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy that Kaden yelled at?
Oh. Apparently, I got an invite to go on Crapcast for Outer Pangea. I'm sure they want to talk about EVS and whether or not legal action can be taken. So I will be heading over there for a minute, but then I'm going to be heading out. So if you guys want to see me, I'll see you guys over there. Very.
I guess it was, he even knows he's fat. For all this fun and more, there's one place to go. Here on Sean Martin's Potentially Criminal
It'll redirect, don't worry.